Good morning, everybody. Happy Wednesday. Welcome to TCF Live. My name is Dan Soul. I will guide you through a 3-hour Courtlandia journey today. Start in Michigan, Judge Anzalone.
All right. I believe Kathy is Kathleen DeLine. So if you could unmute your device and start your audio, please. Hi, are you Kathleen DeLine?
Yeah, I am.
Okay, this is file number 2022-49188DM in the matter of Kathleen Joe DeLine versus John Hiram DeLine III. This is the time set for a show cause hearing. Let's see here. So pretrial release order, posted bond, and that. All right, and there was a $25,000 bond. So, Mr. DeLine, were you previously appointed court-appointed counsel?
No, I was not.
Okay. All right. So hold on. Let me get back there. Trying to figure out. All right, there was a motion and order for show cause for contempt on support dated April 24 of 2026. Miss Adams, is that what we're here on, the front of the court show cause?
No, ma'am. We're here on the retirement for the military. Was this show cause?
I'm sorry. Thank you. All right. Well, there's another one too.
Yes.
All right. So, all right.
That's on the 22nd.
Oh, okay. All right. So, Mr. DeLine, you had failed to appear for a review of your military pension and basically didn't comply with court order forever. So, Mr. DeLine, why don't you tell me where we are in this military pension?
Friday last week, I paid the $500. Yesterday at 4:30, I emailed them a copy of my point retirement worksheet. Everything on my end is done that is needed to be done to split the military pension. It is now in Kathy's hands to pay her $500 portion to the lawyer.
Okay. So, Miss DeLine, so is that all true?
I spoke with the office yesterday morning, confirmed he did pay his 500. At that point, I paid my 500, so it's all paid for. At that time, they did not have the paperwork from the military.
All right. Mr. DeLine?
Yes.
When did you send it?
I received it in my email, and as soon as I received it from the military, I sent that email at like 4:30, 4:45 last night. So it should have been in their inbox this morning when they came into work.
Mr. DeLine, you sent it yesterday at 4:30, yes?
Yes.
All right. So, Kathleen DeLine, do you want to take a moment and call and see if they got it?
Yeah, I can do that.
Okay, so why don't you do that, and we'll give her a minute to do that, Mr. DeLine. Thank you. All right, Mr. Murphy, who are you with in the courtroom?
I have Mr. Castilla, Your Honor.
Mr. who?
Castilla. He's got a show cause that he needs to be arraigned on, I believe, and then we're gonna set trial on the underlying.
All right, okay.
I'm sorry if I mispronounced his name. I'm horrible.
I can't hear you.
So I'm sorry if I mispronounced his name. I'm horrible.
Okay.
I'm sorry.
Okay, so give me just a moment. Anybody in here represented by Mr. Malaro? You are, right? All right, Mr. Malaro, I'm gonna bring up Mr. Perez. I do have Mr. McCready now. Mr. Perez, why don't you come up to that podium?
I'll wait for you to tell.
Yeah, no, good job. That way, you know. All right, you stand right at that podium. So this is file number 2025-22457FC in the matter of the people of the state of Michigan versus Rudy Mario Perez. I have Salvatore Malaro appearing on behalf of Mr. Perez. And I have Dave McCready appearing on behalf of the prosecutor's office. Are you my prosecutor all morning, Mr. McCready?
That's correct, yes.
All right, good. All right, so Mr. Perez has appeared here in person. I have a letter from Darren Coast dated June 8th of 2026 that states Mr. Perez has done a fairly good job being on GPS tether. He lets me know when he has doctor and counseling appointments, and there are no concerns to report. All right, so Mr. Malaro, this is the date time set. Let's see. Got that, bond, a waiver. I think this is almost the first pretrial, maybe.
Your Honor, can I say something?
No, not yet,
Okay.
because I'm talking. All right, so, Mr. Malaro, your client would like to make a statement.
Yeah, I'd prefer he didn't, Judge, but
So, Mr. Perez, you have an attorney, okay?
Yes.
And most attorneys, their biggest concern is their client saying something they shouldn't say on the record.
Oh, it was just gonna be about this tether.
Well, okay.
I had it off for 3 days already, because I had. to
Rudy,
get it.
Rudy,
Yes.
we will address that issue when it's in a few minutes, okay? So just
Okay,
relax.
all right. Okay.
Okay, all right. So, Mr. Malaro, date and time set for pretrial. How do you wish to proceed today?
First, Judge, we're going to need to adjourn this matter out. As the court is probably aware, I will be leaving the office Friday.
No,
the-
that's the bad news I just heard, and we will miss you, Mr. Malaro.
Well, I'm probably not bad news for some. But Mr. Perez's file is pretty extensive. He's been very diligent in maintaining contact with me and in the preparation of this case and his defense. So I would ask probably for a 60-day adjournment for whoever gets assigned. Since it is a high-level felony, I think it'll need to be given some special attention, I imagine. And then we'd like to address the issue of his bond conditions, Judge.
Okay, why don't you address the conditions of his bond first?
Your Honor, I took this case over for Mr. Glazer. He does have his tether, as you just indicated. The report from Mr. Coast about the tether has been very positive. It is a financial burden on Mr. Perez. After meeting with him numerous times, he also, his mother accompanies him to the office when I meet with him privately in my office. I don't know that the tether's necessary. In fact, I would argue it's not. I don't think he poses a risk to either the person involved in this or the community at large. And so I would ask the court to remove the bond condition of the tether requirement. And if the court wants to perhaps have him check in with Mr. Coase on a, bi-weekly or semi-monthly basis, I think that might perhaps solve any concerns the court and the state might have regarding Mr. Perez's whereabouts.
All right, Mr. McCready.
One concern here is I know Mr. Perez has contacts in Texas. I mean, he has a criminal history out of Texas. So to that extent, I do think there is some type of flight risk at least. And I don't see it being an enormous burden to have that tether. He is charged with, serious offenses.
All right. Okay, so Mr. Perez, you are charged with 2 counts of criminal sexual conduct, one being a first degree, which carries a maximum penalty of life in prison. Do you understand that?
Yes,
The allegations against you are extremely serious.
yes.
In light of the fact that the allegation is that the child was under the age of 13, I'm surprised you're not in jail right now. But that being said, I will remain comfortable with you continuing to wear a tether because of the nature of the offense. So I'm not going to remove your tether.
Okay, the other tether that I had, this is a newer one because the other one malfunctioned. So they changed the tether. They checked,
That's not me. That's something you deal with Mr. Coast or whoever you're doing your tether with, okay?
okay.
All right, so Mr. Malaro, Mr. Perez will be assigned another attorney. My next available pretrial, Miss Adams, I'm gonna need a notice of hearing from Mr. Perez, is July 29 at 8:30 in the morning. So Miss Adams, if I could get a notice of hearing from Mr. Perez for July 29 at 8:30 in the morning. So Mr. Perez, have a seat right at the end of that bench right there, and we'll give you a notice of hearing. So that way, no, at the bench behind you.
Oh, right here.
Yeah, right there. And then if there's any issues with your tether, stay in contact with Mr. Coast and the company, all right?
Well, I didn't know something was wrong. With
Okay,
it.
all right. So Ms. Adams will get you a notice of hearing, okay?
Okay.
Thank you. Mr. Malaro, I don't have anybody else here for you. I'm gonna call the jail to get your clients out. You have one in the jail, so I'll call for that one now, all right?
All right, thank you, Judge.
You're welcome. And then, I can take Mr. Castillo or,
No,
hey, this is Judge Anzalone. Good morning.
good morning. What can I help you with?
I would like to see Gary Bowerman.
Bowerman?
Yep,
Or
thank you. Bye.
Bye.
Castilla, right? Castilla?
Yes, ma'am.
Castilla, okay. All right, sorry about that. Thank you. I have my phonetic Castilla on there. Okay, so this is file number 2026-22609FH in the matter of the people of the state of Michigan versus Enrique H. Castilla. I have Dave McCready appearing on behalf of the people. And I think this is an Alexander Bayonetto file. And
Correct.
then I have Matt Murphy appearing on behalf of Mr. Castilla. So everybody pause for a minute because Miss DeLine is back. So I'm gonna go back to file number 2022-49188DM in the matter of Kathleen DeLine versus John DeLine. So Miss DeLine, you're back. Were you able to verify they received the paperwork?
I did. She said she did receive an email and it looks like it's what they need. So we should be set up.
Okay. So do you want me to set a review date for this, or do you feel that you've got everything you need?
At this point, I think I've got everything that we need.
All right, very good. So I will dismiss the contempt of court at this point because he has complied. That means you won't have to come back to court again. Mr. DeLine, there will come a point where you have to sign some paperwork. I expect that to be signed within 24 hours. And otherwise, you can show cause you back in. Good luck to both of you. Thank you.
Thank you.
Thank you. You're welcome. Back on the record in file number 26-22609FH. Sorry about that. So, Mr. Murphy, how would you like to proceed today?
Yeah, I think there's, I thought there was a show cause that had to be arraigned on. We wanted to set trial on the underlying charge. Mr. Castilla, I'm sorry.
Castilla.
The problem I ran into with his case, Mr. Bayonetto is offering for him to plead as charged, the OWI 3rd. He resides in Westland, which is Wayne County. We've reached out to them. They won't take a transfer case for their specialty court, for the sobriety court. He doesn't qualify here because he's not residing in this county. So I've ran into kind of a roadblock in regards to what we can do. So again, we're asking it to set trial, probably a bit of ways out, sometime past the summer. I'm not sure what the court schedule is. I was going to, because also if we are going to trial, I need to try to see if there's some experts we may need to retain or something like that in regards to actually looking through some of the things in the case. So I would need some time for that to occur. But again, in regards to these show causes, I think there's other outstanding ones he was already charged with. We'd ask for those to be set. I guess if you want to do a hearing, sometime shortly before the trial, or we could just have him for a pre-trial at the trial. I'm not sure whatever the court wants to do. But again, I think there's still one that needs to be arraigned on.
Okay. right, I do have a letter dated June 8th of 2026 from Darren CoStar, or Darren's here. Darren, would you like to provide an update?
Yes, Judge. I do have an additional contempt of court where he registered numbers yet again. It's his fourth date in which he registered numbers. He tested positive for alcohol on February 27th, March 4th, May 13th, May 24th. On occasion two, it's showing that he's missing tests, but that might not be his fault. As the unit is having trouble obtaining GPS signal. He claims that it's a faulty device. He actually swapped out devices. Smart Start took a look at the previous device and found no problems with it. It's their belief he's been consuming intoxicants. So if he is to remain out, my suggestion is that we actually switch him over to a Scram device so we get 24/7 readings.
Okay. All right, do you want to respond to that, Mr. Murphy?
Your Honor, in regards to a scram device, I think that we'd be asking for something like that. Mr. Castilla, yeah, I'm sorry. He is adamant that he's not guilty of these. And I think that would be the best way for him to show the court, other than giving samples of blood or something like that, for it to increase the regimen of testing. So I'd ask the court to do that. As a way in lieu of incarcerating him. Obviously, the concern obviously the court would have is abiding by the bond condition. So I'd ask the court to consider that, imposing the GPS, or I'm sorry, the scram unit on him in lieu of incarcerating him.
All right, so no objection to scram.
No.
All right, so I guess you don't really need to weigh in on that. Mr. McCready says they have no objection to a scram device. All right, so Mr. Castilla, on the show cause for testing positive on May 13, February 27, and March 4 of 26. Those are contempt of court. Do you understand they carry a maximum penalty of up to 93 days in jail? Speak up.
Yes, ma'am.
Okay. Now, Mr. Murphy has discussed those contempt of courts with you?
Yes, ma'am.
All right, and you are satisfied with Mr. Murphy as your attorney and the advice that he has given you?
Yes, ma'am.
All right, Mr. Murphy, how do you want to proceed on the contempt of court?
Your Honor, at this time, we're entering a not guilty plea, asking the court to set it. Again, with the underlying charge being set for trial, I don't know if the court wants to have a hearing on this before or after the trial. But whatever the court schedule, whatever its court schedule best, would ask for a hearing to be scheduled on all of these, I guess, so we can get them all wrapped up. I would ask for it to be sometime before the trial date, because that could indicate, or that could change depending on, what the trial.
All right. 1 day for a trial?
Yeah, I would say probably maybe 2 hours, all 20 total.
And Mr. McCready, would you agree no more than 1 day?
Well, I mean, if he's calling experts, that kind of puts it.
Yeah, I guess that would change. So, yeah.
All right, I'll do 2 days. So, Ms. Adams, I'm looking for a 2-day jury trial. Mr. Malaro, while I'm waiting for that date, do you need a breakout room with Mr. Bowerman?
I do not.
Okay.
Judge, we could do Tuesday, September 8th through the 10th. Or the 9th.
Nope, that would work for the defense, Your Honor.
All right. Mr. McCready is like, oh, that should work for Mr. Bayonetto.
As far as I'm concerned, it's a great date.
Okay, so I'll set trial September 8th, and Miss Adams, when I'm done with this, could I get a copy of this from Mr. Castilla? All right, and then let's do a final pretrial August 26th. at 8:30 in the morning. And I will require, I'll set that as a motion deadline, as well as the date voir dire questions and jury instructions will be due. We can address all those issues on that day. Anything else?
Nothing further from the defense room.
And Mr. McCready?
Nothing further for the people. Thank you.
All right. I'll enter a plea of not guilty on the contempt of courts. We'll set everything over to that August 26th pretrial. Ms. Adams, if I can get a copy of the scheduling order from Mr. Castilla. So have a seat at the end of the bench and we'll get you a copy of that, all right?
Yeah.
Good morning once again, everybody. It is TCF Live on this lovely, lovely Thursday. It's a beautiful day here at the bunker. The sun is shining. The birds are not yet on fire. And Ellie is cuddled up, sleeping between my feet. Everything you can ask for as you're putting on a fine, fine court show. So let's stay in Michigan, but let's go to Judge McNally, where a certain guy by the last name of Man, first name of Hoarder, is sitting in the room. So hopefully we'll get to him soon.
Your name? Can you speak good English? No? Do we have an interpreter here coming in on this one, Heather?
Yeah, yes, we do have a interpreter coming in. I believe it's through the services that we have one coming in. They should be here soon. He's scheduled for 9:15.
We have to wait. Can you convey that to him with that Google translator?
If he comes up to the window, yes, we can.
Good enough. Mr. Bazzi, I'm not going along with this. I'm sorry. Call in Mr. Urich. Have a seat. Have a seat. John, direct him to a seat.
Just right there.
He can't, he doesn't understand us.
Right there, just
Listen. Mr. Urich, please.
While we wait for the interpreter or whatever they're going to do next, Barbara, thank you for the $10. It's Hoarder Man Wednesday. Yes, indeed it is. Thank you so much.
Mr. Bazzi, I need you to stop walking. Just get someplace close, if you would, please. People against Nazaniella, Azmaro, 26W842878. Your name, Mr. Bazzi?
Good morning, Your Honor. Hassan Bazzi, P78448 on behalf of Mr. Azmaro. Judge, I had a chance to talk to the prosecutor. If you're not going to willing to go with it, I believe they're going to reduce it down to impeding traffic. I do have authority to accept that
Come on
responsibility.
in here, Mr. Urich. Your name?
William County City.
All right, listen. Fashion guy, whatever. I don't feel comfortable. I know this is the prosecutor. They just wrote a defense lawyer. Not long ago in Woodhaven on Hall, she was upset because I said she thought she was going to get it dismissed. I can't treat people better, just for the record. I got a ticket 8 months ago, and I didn't ask anybody to dismiss it. I just don't feel comfortable. I like this young lady. She's eligible for impeding. Mr. Bazzi, I'm not trying to step on toes, but I'm not going to.
Absolutely not.
If I make exception for them, I got to make it for firefighters, police officers, unemployed fishermen, and then it's ad nauseum. So would you rewrite that up as impeding? I'll take that plea and we'll set it up, and please give her my condolences, but I can't go along with that. So I'm going to ask
Well,
you to, seriously, otherwise I got to do it for everybody.
I get it. Fair enough.
He's writing that up. Are you authorizing that plea on behalf of Ms. Azmaro to impeding?
Yes, Your Honor.
All right, to that charge on her behalf, responsible or not responsible?
Responsible.
All right, I understand. I understand some would do this. I hope everybody understands. I'm not trying to be mean. I just got to do the right thing. Okay. I got to charge her 160. She had one issue back, it looks like, in 20, and I'm going to have the balance due. I'm going to give her till the 17th to pay. Okay, Mr. Bazzi?
Thank you, Your Honor.
160, please accept it to impeding. Have a great day.
Thank you, you too.
Thank you. All right. Kevin Prince. I don't have the file though. I need the file. We have Kevin Prince's file, John?
No, we weren't given his file.
I was just giving the blue back.
We got it. Can't do things without files. So,
Pam was.
Heather, I need the file on,
It's a probation, so Beth told them. She didn't need the file, it's the blue back.
yeah, Heather, I'm gonna need the file on this, please, okay, Kevin Prince? It's 25B 726-159. He's in my sobriety court. I'll start the arraignment without it. Sir, your name. All right, so I saw you this morning. I said I couldn't really talk to you about it because we had a status review. And I went ahead and said we'd handle this when I came in. And what I have is that on June 7th, that you were positive for alcohol on your interlock device as follows. June 7th, 10:26. I'm sorry, Mr. Graziani. I did tell them to set him up with a lawyer. Your appearance?
Okay, John Graziani, bring on behalf of Kevin.
So you haven't been arraigned yet, but I'm going to go ahead and indicate for the record that they think that you were positive for alcohol on your interlock device on June the 7th at 10:26 a.m., 0.058, 10:27 a.m., 0.049, 10:28 a.m., 0.042, 10:29 a.m., 0.045, 1:15 p.m. on that date, 0.027, 1:16, 0.025, 1:17, 0.026, 1:20, 0.027, 1:21, 0.024. And then the next blow, the next day, you were, according to them, clean. There was 0.000. So with that, that is the charge. If you plead guilty at any time here, or if you're found guilty, you could get 5 days on this. This would be a first technical violation. Do you understand everything I've said? All right. Did you sign, read, and understand an advice of rights revocation of probation form?
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes, sir.
All right. Mr. Graziani, how's he going to proceed here?
Judge, we waive the formal reading and he will be pleading guilty to the violations.
All right, so you want me to enter a not guilty plea for purposes of arraignment? Okay. So, sir, do you understand what your lawyer has just said?
Yes.
Call in Beth, please. If you plead guilty here, you understand the possible penalties.
Yes.
You understand your rights.
Yes.
If you plead guilty, you're going to be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes, sir.
All right. To the charge that you tested positive on the interlock device for alcohol on June the 6th, on those dates and at those times. 10:26 a.m., 0.058, 10:27 a.m., 0.049, 10:28 a.m., 0.042, 10:29 a.m., 0.045, 1:15 p.m., 0.027, 1:16 p.m., 0.025, 1:17 p.m., 0.026, 1:20 p.m., 0.027, 1:21 p.m., 0.024. How do you plead to that?
Guilty to that.
Did you consume alcohol?
Yes, sir.
What did you consume?
Beer of non-alcoholic and then 4 shots of tequila.
Non-alcoholic beer and 4 shots of tequila?
Yes, sir.
Was it on an empty stomach, sir?
Yes, sir.
Are you on probation or parole?
Yes, sir. Yes.
On any other report?
Oh, no.
Anybody force you to plead guilty? Thank you. I'll accept the plea. I find it to be an accurate plea, made voluntarily and understandingly. The plea is accepted. I'm gonna need to wait for Ms. Wilds. There you are. Thank you. He's pled guilty. Your name?
Elizabeth Occupation, Your Honor.
All right, let me just make a note here, please. Give me 1 second. All right. What would you like to say?
Judge, this is a gentleman who's had long battle with alcohol. He had a case when he was 21 years old, and obviously he concluded the 7 years since his previous one was at the age of 31. He made a mistake. We're asking for mercy. We're asking for no jail time, and also continuation of Mr. Prince being in the sobriety court program. He is a hard worker, Judge. He has several children that he's supporting with his fiance. He works at Empire today as a carpet installer, and he puts in time. He's a hardworking guy. Again, mercy, Judge.
Anything you'd like to say?
Your Honor, I apologize because that's very myself. There are my kids, girls who dealing with the stress abuse by the floor. I just slipped up and willing to do 100% against this right. Just got a bad time.
All right. My concern is, when did he last blown before? He last blown at 8:36 on June 6th, right?
June 6th at 8:36 PM was his last all zeros before he attempted to start his vehicle on the 7th.
What troubles me is that you were trying to get into a car and drive. And I know you weren't of the legal limit, but you can't do that.
Judge, excuse me very quickly. Mr. Prince, although he screwed up royally, was moving a car. He was not driving the car, sir. It was in the driveway. He simply moved it over for a person. They had to get together that night. It was stupid. I don't know how much drinking was done, but he had moved the vehicle. Is that correct?
Yes.
You were not driving on the road.
I wasn't driving to the other side of the driveway at my home.
What do you think?
It does concern me. He wasn't able to move the car. He couldn't, he could not move the car. His car wouldn't start. He actually, and that was at, he had to wait. So he attempted to blow into the device at 10:30 in the morning roughly. And then actually spent about, I'm gonna say 3 hours. And then was able to move the car, because he was gonna be under the limit come the 1:21 PM. So it took a while for that alcohol to come out of his system before he was able to even start the car. But during that initial time frame, it was all failed. He was not able to open it, or excuse me, able to start.
What would you have again on the breath or blood result at the time of this drunk driving? It was about a 0.42, right, Kevin? The time of the drunk driving, this when you had a kid in the car,
Yes.
wasn't it about 4.42? 461. So you're struggling. I get it. You have to be careful. This can't go on. It troubles me that you were still trying to get into a car. I don't care. And I don't care if you were just moving the car or not. I mean, I get it. That's what you're telling me. But you had a 4.6. You were trying to time it. You started drinking after your last blow at 8:36. I'm not going to send you to jail. So I don't want you to get all nervous on me. You're not going to jail. But you can understand why I have concerns. I think that might be the highest one I've ever seen. I could be wrong. There might have been one at 4.8. But you can understand. I mean, when you get to over 4, wow, you could be dead, comatose. You follow me?
Yes, sir.
So let's just do this. He's going back on the sober link, okay?
Yes, sir.
You're to serve. I'm not going to make you do court work. You're going to do 10 hours of community service, and that's to be completed by, and by the way, let me just finish. That is to be completed in this case by June the 30th. Defendant to be on sober link.
Judge, you mean July the 3rd?
No, I meant June, what did I say? I
You said
meant-
June the 3rd, sir.
I'm sorry, I meant June the 30th. I wrote down June the 30th. My apologies. Defendant to be on sober link device at own expense. At own expense. Until July 28th. And I hate to do that, but I'm really worried about you. You're such a likable guy. You're starting to take shots at tequila. Come on. Let's get this under control, okay? Cost of $50. Can you think of anything else?
He'll need 1 month extension, on his, phase. And I didn't know if you wanted to address anything with his sobriety court restricted license, Judge.
I know. What, remind me, I don't have to do anything.
You don't have to, it's up to your discretion. They will obviously bring that up when he has his DLAD hearing. When he goes to, hopefully apply for his full license, but we don't have to in this circumstance.
What's the date I have to extend phase 1 to?
At least until, September 7th, Your Honor.
Why September 7th?
90 days clean from June 7th when he was positive. That's a scale we're requiring that.
I know, but they're a little harsh with that. I have to do it from today, or can I don't remember. Can I do it?
It's positive, so June 7th.
It was a sober link. I don't have, I mean, interlock. I just can't justify trying to get around that. I'm not going to. I'm sorry. Phase 1 extended until September 7th. I'm not going to take any action on your interlock, but I'm telling you, if this happens again, I'm throwing you out of the program. I'm talking about especially trying to get in a car. You're saying to move it. I don't have any proof of that. I don't know if you were trying to move it or not. You're a likable guy, but we have a job to do here. That's what I'll do. Thank you very much. Have a good day. Set them up with the sober link. It's got to be at your expense. That's why it's a little worse, too, by the way. Thank you.
Thank you, Your Honor.
All right, let's call Bud's LLC 26B150647.
Well, they do the LLC. Lindsay, 13 months with us as a channel member. Thank you so much. All the support you give, the help you give, everything else, very much appreciated. The community would not be the same without you, so thank you. Tim, 5 months as a member. Thank you for all your support and your presence, and I very much appreciate you as well. And you gifted 5 memberships on top of it, apparently, to celebrate your 5 months. So thank you for that, and congrats to our new channel members. So appreciate all of you. Thank you so much. Let's get back to Judge.
I have a stip form here that I just saw, wherever it is. It says that your client's going to plead responsible to Overweight with agreed upon fines and costs of $3,000, correct?
That's correct.
Do you want to do it, or do you want him to do it?
I'll do it.
Okay, and you're authorized to enter into this plea on his behalf?
I am authorized.
On behalf of the company, I should say.
Plea on behalf of Byrd.
All right, to that charge of overweight, responsible or not responsible on their behalf?
Responsible.
Plea is accepted. I'll reduce the fines to $3,000. They were going to be what, about, you said you were going to do 70%, they were going to be 4,100 and some, is that it? Okay, so reduced, how long do they need? Can they pay it in a month?
30 days, please.
Absolutely.
Forgive me, I need to pause for just a minute. Tim just pointed out that I forgot to point out his good looks. Tim, you're a handsome man, and we appreciate that as well. All right, back to Judge.
July the 10th, okay, sir? You have to pay by July the 10th, $3,000, okay?
Okay, we'll do.
Have a great day. Good luck to you. Thank you very much. Thank you. Thank you. Mr. Michael. Thanks, Ms. Lady Carter. I've got to take Mr. Boyd. Do we have a lawyer for Mr. Boyd that he's talked to yet?
Yes.
Where is he? Who is it?
Gentleman in the back.
Was it Mr. Gaith? Mr. Gaith, can you hear me?
Yes,
No,
Judge.
hang on.
I'm here for Miss Russell, Judge, on the retained case.
Yeah, I got it.
Wait. Robert Thomas Boyd. 25BA2557. Ms. Foley Carter, your appearance.
Foley Carter, Brownsville Township.
Your appearance, please.
Rob Perez can be at the Bronson Township Board.
All right. And Mr. Boyd, your name.
Robert Thomas Boyd.
All right. Mr. Crawford, your appearance, please.
Morning, Your Honor. I feel called, Kristen.
All right. What are we gonna do here? Tell me you got good news for me, please. Tell me you got good news for me, please.
No, last time we were here, Mr. Boyd was ordered to complete the sentencing order in its entirety. He has made some progress. Unfortunately, if we were to go line by line on that sentencing order, he is not compliant with all but the winter storage of the boat because we're in June. But otherwise, we're not there yet. We do have updated photos. I don't know if this court wanted to see them.
I do, but Mr. Boyd, I want to ask you a question first.
Okay.
You don't have to do this. We've been going round and round on this since June of 25. Hang on one second. I don't believe I've ever revoked your status either, so I'm almost inclined to have to do that today if I'm going to give you more time. You don't have to do what I'm going to tell you to do, right? I'd like you to call your two sons and have them Zoom in.
Pardon?
Have them use Zoom
Oh,
to Zoom into the courtroom. Will you do that for me, please? Call your two sons. You have two sons.
oh, yes, sir. They work,
I know. They,
7/12, and-
so do all these other people. They're zooming in from work. I'd like you to go out. You don't have to. I'd like you to go out. I'd like you to call them. I'd like to have a conversation. You are forcing me to do something that I don't want to do. You're refusing to take help from people that have offered assistance. Sir, I don't want to debate this. You're a likable man. They've been playing with this for 25 years. I'm frankly to the point where I could be faulted for letting it go so far. You're just not going to listen to me. For whatever reason, I don't think you're being defiant. I dislike judges. I don't like, it doesn't matter to me what the reason. You're just not going to comply. So if I can't get some indication from them that they're going to go over there and help you and understand the severity of this, because I have this belief in my brain, and I could be wrong, that you really haven't discussed the seriousness of this with them. I would like you to go call them.
one works midnight.
I don't care. Good, he's off. He's off.
I can't call him this morning.
What?
He's in bed.
Wake him up,
Oh,
Mr. Boyd.
see what I can do.
Get them both on.
Oh, the other one's, we're not on much talking terms.
You never told me that before. I don't need to know the reasons why.
Yeah.
call your other son, get him on here. Please do that for me. We're gonna give him the Zoom ID. Will you do that for me, John? Give it to him, or Sadie, give him the Zoom ID and have them zoom in, and I'll pass the case and we'll go from there. I'm gonna ask you to stick around a little bit, please. Thank you. You're gonna go out and call him? Yeah, just leave him. Go out and call, you're gonna call them. Call them. Yeah, okay. Robert Earl Curitin.
Alrighty, friends, that is a twist in the Hoarder Man saga. First off, we kind of suspected and wondered what the relationship was like with the sons, because he kept making excuses there, and now he just admitted, at least with one, that they're not on speaking terms, so we know that. Be curious, obviously, to see if they get the other one to zoom in. So obviously, I'm going to keep an eye on Judge McNally's court, and we will go back there if they pull this off. In the meantime, though, let's go to Lake County, Ohio. Judge O'Donnell, say good morning to Judge F. Word.
Ms. Bell.
Thank you, Your Honor. We're here today in the state of Ohio versus Kristen Luddenneken, case number 25 CR 1586. The defendant is present with counsel Jim Reardon. We're here today for an intervention in lieu hearing. 3-count indictment was returned against the defendant, all 3 counts being vandalism, felony of the 4th degree, and the defendant filed a request for intervention in lieu on the 27th day of April, and all the proper reports have been completed.
Mr. Reardon.
Your Honor, my client plans to enter a plea to the charges as indicted, assuming that the court will agree to the intervention referral. I also reviewed the reports, and it appears that she is eligible for intervention. This is a mental health case. Reviewing the report, there are diagnoses of borderline personality disorder, general anxiety disorder, post-traumatic stress disorder, all of which, in my view, contributed to the behavior in this case, which led to the criminal charges. And I believe, given that Ms. Luddenneken has no prior criminal history, that a intervention resolution is appropriate here, and I'm hoping the court grants it, and then we can enter the plea to the charges as indicted. Thank you.
Ms. Bell, as to the motion for intervention.
Thank you, Your Honor. The state has some concerns about the defendant downplaying her involvement in the case. However, other than that, it does appear that she is eligible. Thank you.
All right, I'll grant the motion for intervention. Ms. Luddenneken, how old are you?
I am 31, Your Honor.
How far did you go through school?
All the way through high school. I'm part of Lakeland Community College.
Are you a U.S. citizen?
Yes.
Are you able to read, write, and understand the English language?
Yes.
Prior to coming to court, have you taken any
Only prescription medications, Your
What have
Honor.
you taken?
Lamictal, lamotrigine, prescribed by Crossroads.
Any marijuana? Understand. Three counts of vandalism, all felonies of the 4th degree. Is that your understanding?
Yes, Your Honor.
And then further, at the end of this hearing, criminal proceedings would be stayed and you would be placed on an intervention program. Is that guilty plea? I need to determine freely, knowingly, and voluntarily. I'm gonna ask you questions. If you don't understand, let me know and I'll give you more time. Do you understand that?
Yes.
Yes, Your Honor.
You have a constitutional right to have a trial, either to me or to a jury trial. All 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes, Your Honor.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today and then you get convicted of these offenses, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of these rights?
No further questions, Your Honor.
Do you still want to plead guilty to these charges?
Yes, Your Honor.
Do you understand by pleading guilty, you're fully admitting your guilt to the charges?
Yes.
Do you understand by pleading guilty to these felonies, if you are convicted, then you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control?
I understand, Your Honor.
Now, each of these 3 counts are vandalism. Each are felonies of the 4th degree. Each individually carry a maximum prison sentence of 18 months and a maximum fine of $5,000. Do you understand that?
Yes.
Now, I could give you a consecutive sentence. That means one sentence after another for the separate offenses. If I did that, you face a maximum prison term if you're convicted of 54 months and a maximum fine of $15,000. Do you understand that?
Yes.
Any questions about the penalties?
No, Your Honor.
Do you understand that if you were convicted of these offenses and sent to prison, then upon your release, you might be on post-release control for up to 2 years under the parole authority?
Yes.
If you were placed on post-release control and violated the conditions, the parole authority could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes.
If that violation were a new felony, then you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes.
And if that happened, the maximum prison sentence would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes.
Do you understand that if a prison term were to be imposed, you would be eligible for judicial release?
Yes.
If you are convicted of these offenses, you could be placed on community control for up to 5 years, but if you violated, you could go to prison for 54 months. Do you understand that?
Yes.
Has anybody promised you that I would be lenient on you just because you're pleading guilty here today?
No, Your Honor.
Has anybody promised you what I would sentence you to in this case?
No, Your Honor.
Do you understand if I sentence you, I do not have to follow the recommendation of either the prosecutor or your lawyer?
Yes.
Have you had enough time to talk to Mr. Reardon before pleading guilty today?
Yes, Your Honor.
Has he discussed everything about your case and answered all of your questions?
Yes, Your Honor.
Are you satisfied with the advice he has given you?
Yes, Your Honor.
Have you been threatened or coerced in any way to plead guilty today?
No, Your Honor.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes.
Do you have any questions at this time?
No.
Ms. Bell, if the case went to trial, what would the evidence show?
Thank you, Your Honor. Had this matter proceeded to trial, the state would have proven beyond a reasonable doubt that on October 1st, 2025 in Willoughby Hills, Lake County, Ohio, Kristen Luddenneken and Brian Nagy caused serious physical harm to Pine Ridge Apartments by taking a metal pipe or crowbar and smashing the front entrance door to the apartment buildings. Pine Ridge Apartment is a occupied structure, and the amount of that physical harm totaled $7,850, and that door was used in Pine Ridge Apartments trade or occupation.
All right, Mr. Reardon, anything to add to those facts?
No, Your Honor.
Ms. Luddenneken, did you hear what Ms. Bell said, that the facts would show if the case went to a trial?
Yes, Your Honor.
Are those facts true?
Yes, Your Honor.
All right, what is your plea to vandalism and count 1, a felony of the 4th degree?
Guilty, Your Honor.
What is your plea to count 2, vandalism, a felony of the 4th degree?
Guilty.
And what is your plea to count 3, vandalism, a felony of the 4th degree?
Guilty.
Mr. Reardon?
Your Honor, I witnessed the defendant sign written plea of guilty. Mr. Reardon and I have signed the same.
Ms. Luddenneken, is this your signature on the written plea of guilty?
Yes, Your Honor.
And did you sign it voluntarily?
Yes.
Do you want me to accept your written plea of guilty?
Yes.
I'll accept the written plea of guilty. Defendant was present. Mr. Reardon advised of all of her rights, being a knowing, intelligent, voluntary waiver. She understands the nature of the charge, the consequence of her guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary, will accept her plea of guilty to 3 counts of vandalism, all felonies of the 4th degree. I'm going to stay the criminal proceedings at this point. So what happened here this night?
We got locked out, and it was several times that we have been locked out. I was involved. I do take responsibility for being involved. I know it was wrong, and I do apologize.
So why did you guys do this?
We got locked out, and it was a matter of the child was outside in freezing temperatures, and we needed to get in, and the fobs were not working.
So where'd the crowbar come from?
He found that before I even reached him,
Where did the gloves come from?
at home, from work.
So this wasn't a spur of the moment thing, right?
No.
Okay. So how much damage did you cause?
He shattered the key fob scanner, as well as the door,
So where do you guys live now?
at North Marginal, at Bay Ridge Condos,
When did you move there?
March,
How long did you live at Pine Ridge?
for about 2.5 years,
How long did you have these problems with,
the whole time.
why
And
didn't you?
they went unsolved and unrecognized.
Okay. Why didn't you move before then?
Didn't have the funds at the time.
Where are you going for your mental health treatment?
Crossroads Health Services mentored.
Where?
Crossroads.
What do you do there?
I do, I have a therapist and I have a, she's a, the one who prescribes my medications. Psychiatrist, yes, my bad.
What is your mental health diagnosis?
I am diagnosed with CPTSD.
What's that?
It's post-traumatic stress disorder, but it's usually developed
And what else?
over a short period of time.
What else? Any other conditions?
Borderline personality disorder and getting tested for autistic.
How long you been treating there?
Since I've been 25,
How often do you go?
weekly. Sometimes bi-weekly, depending on her schedule.
Do you go to any other doctors?
Not at the moment.
What's going on with your co-defendant's case?
He is upstairs with Judge Condon. He has pled. It's set for sentencing at the end of July.
Are you employed right now?
No.
When's the last time you were employed?
2021.
What do you do?
I worked at Bluefish Aquariums back then. I currently am a stay-at-home mother.
How old are your kids?
The youngest is 2.5, the oldest is 10.
All right, so when you were here in April, when you went over for the interview, you tested positive for marijuana, right?
Whom tested positive?
You did.
I tested positive.
At the referral, yes, Your Honor, but at the interview, she was negative.
Right. So why were you using marijuana?
For medical purposes for my heart.
What?
Medical purposes for my heart.
Who prescribed marijuana for a heart condition?
No one prescribed it. I just used it on my own.
Okay. And what exactly made you think that was a good idea?
Because I did not have the funds and the means to go to a doctor just yet.
Okay. And what made you think that marijuana was
It helps.
something to be used to treat a heart condition?
It helps slow the heart rate spikes that I get.
So did your doctor at Crossroads know you were using marijuana?
Yes.
And what did they say about it?
That she would like me to be on medical if allowed.
Okay. Makes me question any confidence I might work up over Crossroads. You aware of that,
Yes.
Ms. Canals?
I don't have any records indicating that they told her she should use medical marijuana.
You know why? 'Cause
I don't know that that's what they said. They said that if she were recommended by some medical person.
Well, then she can call a witch doctor in Nebraska and say, I have a heart condition, and they'll give a thing for a recommendation for medical marijuana. It's the dumbest thing I've ever heard.
I'm just
That's
saying.
stupid.
I just
okay?
don't think Crossroads
You-
recommended it.
Well, that's what she told me.
Well, no, I think she said
So
Crossroads.
listen to me, okay? You're on medication for mental health, okay? Stay off the marijuana.
Yes, Your Honor.
I'm not a medical doctor, okay, but I'm pretty sure, it's like the guy who was in here that had a horrible heart condition and was overweight, and he decided that he was taking meth to lose weight, okay? And I told him that's a bad idea, okay? Treating a heart condition with marijuana is a bad idea, so stop doing it.
Yes,
You
Your Honor.
can't smoke marijuana. I don't give a shit if somebody tells you that medically you should do that.
Okay.
Then maybe that's a bad idea, so you're not gonna do it.
Right.
Because that'll that'll terminate your intervention plan, and you'll be a convicted felon if you start doing that.
I don't plan to.
I mean, it's legal, so obviously it's the cure-all that society was looking for, right? Isn't that right? Unbelievable. All right, I'm going to place you on a 5-year intervention plan.
Okay.
You're going to continue your treatment with Crossroads and follow all recommendations. Now, in the event they recommend marijuana, then you're not to follow that recommendation.
Correct.
Okay. You're to have no illicit drugs or alcohol, and you'll be screened. You're to go to only one doctor, one dentist, and one pharmacy for prescription medication. You're to take any medication you're prescribed only as it's prescribed. You're going to sign releases so probation can get your records, and you're going to pay the costs and supervision fees. Ms. Knaus, any other terms you think are applicable?
No, Your Honor, thank you.
Do you understand the terms?
Yes, Your Honor.
If you don't comply with the terms, the state will file a motion to terminate your intervention plan. If I find you violated, like smoking marijuana, then I'll terminate your plan and you'll be convicted of 3 counts of vandalism, felonies of the 4th degree. Do you understand that?
Yes, Your Honor.
And then all those penalties that I talked about come into play. Any questions?
No, Your Honor.
Anything else, Ms. Bell?
Yes, Your Honor. The defendant has 1 day of jail time credit, so I would ask for 1 day jail, 1 day credit, and also $7,850 in restitution.
Have we confirmed that? I mean, I don't think we finished talking about that issue.
So they got back to me on their insurance. Their deductible is $75,000. This is not something they put through insurance.
But they could have.
Yes, but they didn't.
What is this?
The final number?
No. What are you guys talking about?
So,
was there,
as the court's
what
aware.
do you have from them that shows this?
I have receipts in my email.
I have no doubt about the damage amount. The question is insurance. So as everyone's aware, if insurance applies and insurance covers it, then there's no restitution. If the victim here chooses not to use its insurance, I'm not so sure the defendant is responsible. I don't know that answer for sure, but I tend to think that if insurance could cover it.
The victim is claiming that their deductible is $75,000. This was significantly less, so they did not put it through their insurance.
See, what?
Their deductible is $75,000, so it's more for catastrophic events, so they paid for this out of pocket.
Okay. And where is that document?
May I approach, Your Honor?
I believe you.
Somewhere in there it talks about the deductible or what?
No, I just have that information from the victim.
Okay. Well,
And then the question becomes, if she's not convicted, if we're in the stay period.
I wouldn't play around with that fire.
Yeah, listen, we're not gonna hold it up over that.
I wouldn't, because if I find restitution is applicable, then that's gonna be a term of the plan.
Which is fine.
You can always appeal that to the 11th District Court of Appeals if you want.
Yeah, I know.
And I would be jointly and severally liable with the co-defendant.
Okay. here's what I want, okay? I'm not gonna do the restitution right now, but I want something from them that explains this thoroughly to me, so I can be satisfied that they're not double dipping.
Fair enough.
So when I get that information, then we'll come back for potential additional terms of intervention.
Sure.
Even though, if it's applicable, and I find it's applicable, even though she's not convicted,
Right.
I'm gonna implement it.
Understood.
Anything else, Ms. Bell?
Nothing further, Your Honor. Thank you.
Mr. Reardon?
Nothing further.
Ms. Canals? Okay, we're adjourned.
All right.
Alrighty, friends, good morning once again. It is TCF Live on this lovely, lovely Wednesday. It is good to have you all here. Let's stick with an equally intense judge. Go up to Michigan, Judge Aqualina.
25-1322 FH, people of the state of Michigan versus Dakota Morales. Counsel, your appearance for the record.
Good morning, Your Honor. EPA Barbados on behalf of the people of the state of Michigan.
Aaron Robinson, Assistant Public Defender for Mr. Morales.
Thank you, sir. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Have you taken, you may put your hand down. Have you taken any medication yesterday or today?
No.
Are you supposed to be on medication you're not on?
No.
Any sign of fever, COVID, or other illness?
No.
We've had enough time to speak with your attorney.
Yes, Your Honor.
I am in receipt of a plea agreement, so there'll be a plea today, is that correct?
That's correct, Your Honor.
And sir, I have a address now in Phoenix Drive, which is different than I have on the felony information, is that correct?
Yes.
Okay, who lives there with you?
It's my grandmother's house.
Okay, and are you employed?
Yes.
What do you do?
I do landscape and I do construction.
Okay, very good. And was the crime that you are pleading to, were you on probation, parole, or bond conditions before another judge?
No, Your Honor.
Okay. Are you a U.S. citizen?
Yes, Your Honor.
On behalf of the people, what is the plea agreement?
Yes, Your Honor. The defendant will be pleading to an added count 3 of attempted carrying a concealed weapon. Upon successful plea and sentencing, count 1, carrying a concealed weapon, and count 2, driving a license suspended, will be dismissed. There's also an agreement to no upfront jail at the time of sentencing. And obviously it is part of the statute, but there's also an agreement for forfeiture of all weapons seized as a result of the sentence.
Full, fair, accurate, and complete?
It is, Your Honor.
Full, fair, accurate, and complete, sir?
Yes, Your Honor.
All right. And was the weapon yours or someone else's? All right, so that would be forfeited today, you understand that?
Yeah.
And I don't know if there's any other contraband that was seized, but all contraband is seized, do you understand, and forfeited, do you understand?
Yes.
All right, very good. And what was stated is full, fair, accurate, and complete, sir, you understand all of that?
Yes, Your
Count 1 and 2, are you waiving reading?
Yes, Your Honor.
As to count 3?
Yes, Your Honor. People of the state of Michigan versus Dakota Joaquin Morales, state of Michigan, county of Ingham. In the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and on the location described below, the defendant in an added count 3 attempted weapons carrying concealed. On or about January 25th, 2025, at Samantha/Cedar, Lansing, Michigan, 48911, Ingham County, State of Michigan, the defendant did attempt to commit the following listed offense, and in the attempt did act towards the commission of that offense, but failed in the perpetration or is prevented in the execution thereof, contrary to MCL 750.92. That being weapons carrying concealed. Did carry a pistol, whether concealed or otherwise, in a vehicle operated or occupied by the defendant, to wit, a Chevrolet Trailblazer, contrary to statute. As a attempt. This is a misdemeanor that is punishable up to 2.5 years or $2,500. Mandatory forfeiture of the pistol, weapon, or device, the statute. And court shall order law enforcement to collect DNA identification profile sample before disposition or sentencing, if not taken at the time of arrest, and against the peace and dignity of the state of Michigan.
All right, sir, I'm sure it's just because I do it too. We just kind of do these things rote, but it's not, you said it was a misdemeanor, but it's a felony.
It is a felony. I apologize.
That's
Your Honor.
okay.
Yes.
It's not a high court misdemeanor because
That is correct.
Just what, okay, just making sure.
I apologize.
It's not a problem. We just have to catch each other, that's all. Counsel, you would agree with all of that?
Yes, Your Honor.
All right, sir, did you understand what was just read?
Yes, Your Honor.
So you understand attempted carrying concealed weapon is punishable by 2.5 years, or $1,250. And we already talked about the weapon and contraband being forfeited.
Yes, Your Honor.
It looks like you signed the advice of rights form. Did you read it before you signed it?
Yes, Your Honor.
Did you understand what you read?
Yes.
And if you had any questions about your rights, your attorney was able to answer those for you?
Yes, Your Honor.
And do you have any questions about your rights of this court?
No, Your Honor.
And sir, you're pleading of your own free will?
Yes, Your Honor.
No one forced, threatened, coerced, or promised you anything other than the plea agreement?
No, Your Honor.
And you decided to plead after you talked with your attorney?
Yes.
And you've been satisfied with the representation of your attorney, is that correct?
Very, Your Honor.
All right. As to count 3, attempted carrying concealed weapon, how do you plead?
Guilty.
And do you understand that by pleading, you're also giving up your automatic right of appeal? If you choose to appeal, you first have to ask permission of the Court of Appeals to appeal?
Yes, Your Honor.
And also, do you understand that there is an agreement for no upfront jail? However, if you violate the law or bond conditions between now and sentencing, I don't have to honor that?
Yes, Your Honor.
However, if everything goes well and I don't honor it, and I don't want to worry you, I usually do, but sometimes there's something in someone's writing, so I don't honor it. But if I don't honor it, what happens is you're allowed to withdraw the plea, and this goes back to the pretrial stage. Do you understand that?
Yes, Your Honor.
Has anyone told you what I will do at sentencing?
Yes, Your Honor.
Well, have they promised you what I'll do at sentencing? I know your attorney's just gone over very thoroughly options, but she or no one else has promised what will happen. Is that correct?
No, Your Honor.
That's not correct? Or that is correct?
Oh, it is correct. I'm sorry. Yes, Your Honor. I'm sorry.
I knew what you meant. It's just that I know you're a little nervous. It's just that when we read it, it would read the opposite. So I need to make sure the record is clear. Okay.
Yes, sorry.
Okay, and that's because I don't know what I'll do at sentencing. I can't make a decision until I'm fully informed, and I'm not informed, and that's just why I asked you that, because no one could promise you. They don't have a crystal ball, and neither do I. Do you understand? All right, very good. I need you to just speak up, okay, sir?
Sorry.
That's okay.
I'm on too.
I know you're a little nervous. We're good. All right, did this offense occur on or about January 25th, 2025?
Yes, Your Honor.
In the city of Lansing County, of England, state of Michigan?
Yes, Your Honor.
And was that at a specific location known as Samantha and Cedar in Lansing?
Yes, Your Honor.
Were you in a Chevrolet Trailblazer?
Yes, Your Honor.
Were you the driver or the passenger?
The driver.
And do you know why the vehicle was stopped?
Believe the plates, Your Honor.
All right, so law enforcement pulls you over because of the plates, and then how is it they came to find the weapon? Did you tell them, or did they do a search?
Searched it and.
Did you give them permission to search it?
No, Your Honor.
Counsel, was there something they saw or that led them to believe they needed to search?
Yes, Your Honor. When they pulled over the vehicle, the officer saw someone in the car, I guess, fling an object that appeared to be a handgun into the back of the vehicle.
All right, so if there's any defect, it doesn't sound like it, but just in case if there's any defect in that search, that's being waived at this time?
It is.
All right, thank you very much. Sounds like you explored that option. And sir, it's fair to say the, well, let me see, it was a pistol, it was in your vehicle because you placed it there?
Yes, Your Honor.
And where was it located in the
In the
vehicle?
trunk, Your Honor.
in the trunk?
Yes.
And you didn't have a license to carry concealed, is that correct?
No, I didn't. I was actually planning on doing, but.
No, I didn't what?
No, Your Honor.
He said it was something I planned on doing, but
Didn't make it.
okay, sadly, we see a lot of good intentions.
Yes.
You just gotta follow through, and it's an important issue like weapons.
Yes, sure.
All right, and you would agree with me that a pistol is a dangerous weapon?
Yes, Your Honor.
All right. And you would also agree with me that it was concealed in your vehicle?
Yes, Your Honor.
On behalf of the people, any additional questions?
Just for clarification, Mrs. Morales, it was in the back seat, not the trunk, correct?
It was in the trunk.
The police found it in the back seat though, correct?
No, they found it in the trunk. It's in the video.
So this is a Trailblazer, is the trunk closed or open?
I mean, yeah, it's like the, what do you call it, hatchback or whatever.
Yeah, so it's not in a
It's like a
trunk where you seal the.
It's not a sealed trunk, yes,
Not a
so you
sealed
have
trunk.
access to the trunk.
It's like a third
Yeah,
open
you have,
area.
you have to climb all the way back there to get it to the
Okay,
back
so-
door.
Yes.
Yeah.
We just need to differentiate
Okay.
between, and I figured because it was a Trailblazer, but good question, Council. So it's an open area as part of the car, it's not a sealed trunk.
Yes, yeah, I don't, I never looked at it like that either. I was,
Yeah.
it's a trunk, but.
Yeah, we're
Yeah.
attorneys, we have to look at all the elements a certain way, so I get what you're saying. Because you didn't physically have access to it, but it was still open instead of locked in a trunk.
Yeah.
Okay, you would agree with that? Thank you, sir, you would agree with that?
Yes,
Okay,
yes,
thank
sir.
you. And then the people are satisfied on behalf of your client. Any additional questions?
No, Your Honor.
All right, thank you. Our counsel, where promises, threats, or inducements other than those already placed on the record?
No, Your Honor.
No, Your Honor.
Does court comply with court rule?
You have, Your Honor.
Yes, Your Honor.
I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find there are sufficient grounds to accept defendant's plea. Therefore, count 3 will enter, counts 1 and 2 are hereby dismissed in their entirety. The weapon, any ammunition, contraband that was seized is hereby forfeited. Any outstanding warrants, if any related to this file, are also called and dismissed. Do we have a sentencing date?
July 29th at 10:30.
All right, July 29th at 10:30. Does that meet with your schedule, counsel?
It does.
All right, sir, you'll need to be here today. Please go downstairs and make and keep an appointment with probation. If you cannot stay longer today, then you have 24 hours to call them. It's just so much easier to go downstairs and make and keep that appointment. They need to do a very detailed pre-sentence investigation report, and we can't go to sentencing without it. If you missed that meeting, then I have a standing bench warrant, so you'll be picked up and you'll remain lodged until it gets done. Do you understand?
Yes, sir.
Any questions? All right, good luck to you, sir. Thank you.
Thank you.
TCF Live in hour 2 on this lovely, lovely Wednesday. I've got my eyes on Judge McNally's court. He left for a long time, just got back on the bench. I'm hoping that whatever went down with Hoarder Man hasn't gone down yet and didn't go down like behind the scenes. But we'll see. Keeping an eye there. Let's go for the moment back to Judge O'Donnell, new contestant there.
Thank you, Your Honor. Before you today on State versus Clarence Byrd, file 25 CR 1175. We're here today for sentencing. The state of Ohio has had the opportunity to review the pre-sentence report and is prepared to go forward. Thank you.
Ms. Tomczyk?
Yes, thank you, Your Honor. Mr. Byrd today would like to ask the court for an opportunity at community control. In the alternative, though, Your Honor, if the court does not find that Mr. Byrd is amenable to community control, he would like to ask for the minimum sentence to run concurrent on each count. Your Honor, in speaking with Clarence, he has been extremely upfront regarding this incident. He's been very cooperative to work with throughout the entire incident. Mr. Byrd indicated he does have an issue with drugs. He was selling drugs to feed his own addiction, Your Honor. Mr. Byrd does have a fairly lengthy criminal history consisting of thefts. Your Honor, in speaking with Mr. Byrd regarding that, he did indicate that was to help his drug addiction. Your Honor, his upbringing was a little bit rough. His father was in and out of prison. He didn't have much of a relationship with his mom. The woman who raised him did pass away while he was in the jail, Your Honor, so he has been dealing with a lot. I do understand he is serving a sentence out of Michigan currently. The sentence is for 1 to 5 years. There's been no clear date of release that I can find on the docket, but in speaking with Mr. Byrd, he indicated that he is set to get released in November of this year, and then he'll have the remaining time hanging over his head. With regard to the warrants, it is his intention to get those cleared up as soon as possible and get the past behind him. He does have a 2-year-old son. He does want to be involved with his son's life, so he wants to get all this cleared up so he can be a good role model for his son. Thank you.
Mr. Byrd, what do you want to tell me before I sentence you?
I just want to say that I apologize for wasting your time. I apologize for wasting my time, my family time, everybody that I let down. Being in here, I lost a lot. I lost my life. I lost everything. I missed my daughter's prom, her graduation, 2 of her graduations. Being here is just unbelievable. I just can't believe that I'm in here, that I made a mistake. I acknowledge the actions that I have done, and I apologize for wasting your time again, sir.
Well, you can have a seat. What are you in prison in Michigan for?
A retail fraud.
What did you do to get yourself there?
Honestly, I was getting high, and it's basically a retail fraud is like a theft. So.
In Troy, Michigan, what were you doing in Troy, Michigan?
I went out there to go to the dispensary, and I just fell with the wrong crowd.
What dispensary?
The House of Dank.
What kind of dispensary is it?
It's a weed dispensary.
Okay. What were you doing in Boston in 24?
With the wrong crowd again.
I mean, why in Boston?
I was going out there with some friends.
For what?
Just to go.
Huh?
Just to go out there.
What were you doing in Georgia a month later?
My aunt stayed out there.
Okay. I'm asking you this because you're from Cleveland, right?
Yes, sir.
In March of 24, and then before March of 24, you've got a history of thefts, among other things, domestic violence, assault, drugs.
I have a domestic violence in Cleveland.
Right.
Me and one of my baby mothers got into it, and then I have the assault or something like that. It should be on there. That's an identity theft. So I have one domestic violence. I got a few thefts, and this is the first trafficking that I ever had.
All right, so
basically, I was just all over the place, sir.
I know you were all over the place. You're in Boston, you're in Georgia, you're in Michigan, and then you start selling cocaine here. Why did you start selling cocaine here?
To be honest?
Yes.
For my habit, and I was being greedy.
I mean, you were selling a lot of cocaine. The F3 was, what, almost 15 grams or something like that?
Like 13. Like 13, 14. That was a half ounce.
I mean, where were you getting it from that you were then going out and selling it?
From Clifford.
Clifford who?
This guy I know. I'm just being honest with you, since I just want to get this all over.
Well, that's what we're here for. You got a bunch of warrants also. Why do you have a
Yes.
bunch of warrants out there outstanding?
When I leave here, I'm going to take care of that. In Cuyahoga.
Where else are there?
That's it.
Well, different courts in Cuyahoga, right? You got a Parma Municipal Court,
Yes, that happened, like,
Shaker Heights, Stowe,
yeah, like,
Cuyahoga Common Pleas, Avon Municipal, Bedford Municipal, Lyndhurst Municipal.
I took care of the Lyndhurst. I was taking care of all of them, actually. But then I got arrested in August. And when I got arrested in August, I couldn't make any more court dates. So that's why I couldn't go to no courts, because I was in here.
Are you running around with the same people in all these different states, committing all these thefts?
No, sir.
Who are you hanging out in Boston with?
This one girl I know.
Okay, Mr. Geigerich?
Thank you, Your Honor. State of Ohio and Trust Court to fashion a sentence that's appropriate in this matter, but we would ask if prison is imposed that it be served consecutive to his sentence he's currently serving in Michigan. Thank you.
May I say something?
Yep.
Okay, I've been in prison for 11 months now. This is the worst ever. I'm not even gonna, this is the worst ever in my life. Like, I never been in prison this long. And I never want to come back.
Well, I mean, the prescription's simple. Stop coming back.
I'm never coming back.
Stop running around stealing everything that's not nailed down and quit selling drugs. The prescription is simple.
That's over with in my life.
On the other hand, there's consequences for what you do.
I know. I'm aware of those consequences.
So when you're done with the consequences in all these various courts, then you can start acting like a normal person in society. Then you won't have to deal with this stuff no more. That's the prescription. All right, I've reviewed the pre-sentence report. And I've listened to Mr. Byrd, listened to counsel. I've considered all the provisions in 29-29-11, 29-29-12, 29-29-13, and 29-29-14. And your record goes back as an adult to 17. It's an obstructing official business, misdemeanor, domestic violence, misdemeanor, drug abuse, misdemeanor. Report emergency when no emergency exists, whatever that is, a misdemeanor. Attempted aggravated theft, this starts in January of 24. Misdemeanor, shoplifting in Boston. Theft by shoplifting in Georgia. Theft in Avon, theft in Troy, Michigan, theft in Highland Heights, that's all 24. 25, you got a theft in Highland Heights, a failure to comply with the order or signal of a police officer in July of 25, and then you're selling cocaine here August 7th of 25.
Yeah, I was just going through a lot, sir. I was just all over the place.
I know you were all over the place. You were all over the place doing things you shouldn't have been doing. So you're not amenable to community control. So on count 1, I'm going to sentence you to 12 months in prison. On count 2, 24 months in prison. Those sentences will be concurrent to each other but consecutive to the Michigan prison sentence, with credit for 16 days, and you pay the costs. If you are released from prison in Ohio, At the end of your sentence, you may be on post-release control for up to 2 years under the parole authority with conditions. If you violate the conditions, the parole authority could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. If the violation is a new felony, you could get an additional consecutive prison sentence for the violation, the maximum of which will be the greater of 12 months or the time left under post-release control. Remaining, I'm going to find that consecutive service is necessary to protect the public from future crime by you and for the appropriate punishment, and they are not disproportionate to the seriousness of your conduct. And your history of criminal conduct, as I've outlined, demonstrates that consecutive sentences are necessary to protect the public from future crime by you. The remaining charges are dismissed. The items subject to forfeiture are forfeited to the state. Anything else, Mr. Geigerich?
Nothing, Your Honor. Thank you.
Ms. Tomasic?
Your Honor, just briefly, I do understand that there's a mandatory fine with the felony of the 3rd degree. I did file an affidavit of indigency for Mr. Byrd.
All right, as a result of that, the mandatory fine is waived.
Nothing further. Thank you.
All right.
TCF Live in hour number 2. Hope you're all enjoying your day. I know I am. Let's go back up to Michigan, spend a little time with Judge McNally. Hoarder Man is there, just not called yet.
Don't see anything. We have Amber, Lynn, McPeace. McPeace to my left. Please identify yourself.
What is she going to do on this?
Judge, she tends to plead guilty of
Is that right, ma'am?
Yes, sir.
That's what you want to do?
Yes.
If you plead guilty here, since you've absconded, you could get the 90 days. You understand that?
I do.
Did you sign, read, and understand the advice of rights form here today?
Yes.
I'm gonna need for Jessica on this.
Jessica's out.
Yeah, I know. So just
Oh,
tell them
okay.
whoever's available, probably. If you plead guilty, you're giving up all those rights and we're not going to have a hearing. Do you understand that? All right, to the charge to be able to refrain from consuming alcohol or drugs testing positive for marijuana on October 16 of 25. How do you plead?
Yes.
Did you test positive for marijuana on October 16 of 25?
Yes.
Had you consumed marijuana, say within a week preceding that date?
Yes.
Anybody forced you to plead guilty?
No.
Your plea is accepted to that charge. There's only one count. You only had 2 prior technicals, but again, because this was an absconding, she could get
Understood.
90 days. All right, let me check something here before we're gonna get probation in here. What kind of controlled substance was that again? It's not on the citation. Why didn't she show up here? Can you tell me?
Judge, she just became nervous and overwhelmed. I had a good deal of time talking with her, and she has tremendous responsibilities. She is the mother of 5 children, and she lives.
Are you married? Is she married?
She is not married. She is living with her fiance. She's essentially a stay-at-home mom.
How many children have you had by how many?
It's just 5 children with this gentleman. So,
Okay, you just haven't been married,
Yeah.
but you live with.
Yeah. I'm sorry, Steve.
who gets married anyway these days? Although I believe.
I'm waiting on.
I'm taking the fifth.
I'm gonna toss.
I'm waiting.
No, but no.
All right.
She suffers from schizophrenia, PTSD, severe anxiety, major depression, or manic depression, and she's overwhelmed, and she doesn't didn't have the courage to show up. And again, this is a situation where we're asking for mercy, Judge. She has been taking steps to take care of her mental health. She sees a therapist 2 times a month, in addition to a psychiatrist that's obviously taking medications. And we're asking, in lieu of any jail time, that she be given additional probation. It's my understanding that she has a separate charge that arose Flat Rock, which was public intoxication. No, it was originally public intoxication. It was reduced to disorderly.
I think so.
Okay, it appears it was reduced to disorderly. That's a non-reporting probation, and anything that's given, Judge, I hope coincides with that separate charge.
Ms. Blount's your name?
That's good prosecution, Your Honor.
Anything you'd like to say, ma'am?
I am looking.
No, I was asking her for.
Oh, sorry, Judge. Just, I apologize for waiting for this time by not showing up and really apologize.
What had she done and not done?
Yeah, Sharon, I'm looking at Miss O'Donnell's notes. She did complete 34 total hours of community service. I believe she was given additional hours of community service for her first violation, which was a positive chemical test as well. There's proof that she attended some treatment, but not completion. So there is at least progress towards treatment, but again, no completion. Testing is kind of what you see there, Your Honor, as far as her being violated with a confirmed positive on this violation and a prior violation as well. I'm not sure if monies have been paid. The last communication that Miss O'Donnell had with her was back in September 25, before I think Miss Matisse absconded. And I did not have a chance to look, but there is a note here that she was sentenced on that new charge in Judge Hessen's case on the public intox, but I did not get a chance to see what those terms and conditions were.
Okay.
Judge, she does owe money, but she has indicated to me that she's completed, that other program, the counseling.
Who's Jerry Knudsen?
Thank you, Dan.
He posted, first of all, I need a first page of a register. And can you hold? Yeah, but you never showed up on a case out of, Taylor, an assault case that emanated from January, that, let's see, I don't know when it occurred, but
Yeah, I didn't.
hang on one second. You got a warrant out of Taylor since January, I'm sorry, Lincoln Park, since January 12, 26 on an assault case, simple assault.
Judge, I was not aware of it, sir.
That was.
That was what?
Did you have that charge?
You didn't show up and you got a warrant out for your guys.
Figure everything out. I called up there and they gave me the walk-in days that I can come in and do. To go figure that one out.
Take care.
Take care of like everything that we've been trying to do is take care of everything. So I'm taking away from my 5 kids because I'm the only person that can take care of them. Their dad has to work so he can make the money to take care of them. They don't have like a.
Judge, very briefly.
Let me just say this before we go on. I have no choice but to revoke her 7411 status and enter the conviction. Now I'm going to re-sentence her. I'm going to listen to whatever you have to say.
Judge, this is the way it's that I get where you're coming from. However, I mentioned, however, this young lady has so many issues that have to be addressed, and she needs more extensive counseling with responsible medications. I asked that you continue the 7411 status, Judge, because again, she's been overwhelmed. She had in addition to all the issues she's gone through, she had a mental breakdown in the past 6 months, which when her husband was off work, she went to live at a motel just to get away from all the stuff for about a week. So I hope you understand what she's going through emotionally. Again, she was wrong for what she did, but at the same time, there's extenuating circumstances. I mean, she's 28 years old, has 5 children, and is balancing. What a tremendous balancing act, Judge. That's all I'm asking for. Obviously, no judgment, sir.
Glad you got that in there.
I mean, that takes total responsibility for all my wrongdoings. I'm just trying to make it right now. And I'm sorry that I wasted your time. Not on the man.
Don't worry about my time. I don't know why everybody seems to be worried about my time. This is what I do for a living. I'm not worried about the time. How many hours of community service has she done?
She's complete 34.
It shows a concerted effort to try to take care of things, Judge.
So if I send you for a drug test right today, right now, what am I going to see?
Just my prescription for you.
There's going to be nothing other than that's which has been prescribed by a physician.
Yes, ma'am.
But she did indicate the marijuana, Judge.
Why are you staying with marijuana if you're pregnant?
Well, no, I haven't smoked in the last couple of days, but
When did you come down pregnant?
I just found out like 2 days ago. I missing NLT in mine.
I don't need to get too in depth on this, okay?
There's money like that would be what stuff is. But I do not have the money to take it up this.
What's your husband do? I'm sorry, your father.
He does construction.
Sounds like he's on the laborers council, with the highway, for the judge.
Yeah, we just haven't paid it. We've done it DTE, so I know I don't have money today to just pay it. I'm sorry.
I don't want to get too in depth. When you did you go to a mental health facility?
She did not go in a mental health facility. A friend of hers suggested that she go get away, not to do anything stupid, but to get away like a lot of people need to when they're having a heck of a difficult.
How long were you in this hotel?
For like, look,
What did you do when you were in the hotel?
I just relaxed and like tried to figure out my life, you know, like I relaxed, trying to get my head, I get overstimulated really easily. Just rather say the one part.
She's overwhelmed, Judge.
I don't need you to go into any more depth.
My schizophrenia was back up with it. That's as far as I try to go.
Why aren't you getting yourself some mental health treatment?
I work with a therapist twice a week, and I go to a psychiatrist once a month. I mean, not twice a week, twice a month, and then I go to a psychiatrist once a month.
How long you been doing that?
For the past, I did ice cream back up Florida, but I quit for like a year. Then I thought I made something better, but it obviously made myself worse, and I started writing. But so far, I've done therapy for like 4 years.
And how long, are you telling me consistently you've been at it 3 times a month between the two?
Yeah, consistently.
When's the last time you went to either one of them?
My psychiatrist, I just seen him on the 8th, and my therapist, I just seen her on the May 22nd.
What is that?
I don't know what that was.
Sounds like a train, another train.
I think it was.
I'm gonna still revoke her status.
Thank you, Judge.
I'm gonna give you 4 days jail. I'm gonna give you credit for 4. You gotta promise me you're gonna keep going to those 2 though, okay?
Go to,
Yeah, the mental health treatment and your psychiatrist.
people swear for sure.
You gotta get your life in order, okay?
I
All right, that's it. I'm closing the case. You can tell your father of your children, I gotta think this through again. They changed everything. I think they get the whole thing back, Heather. Mr. Newsom will. I don't know, it used to be 10% and they changed that and there are never enough changes. I just give them all the money back. I don't think we're supposed to keep any of that. Okay? So you could tell the father to call up to the court and he can dial extension. What's yours, Heather? 234 or what is it?
228.
671-0201. Can you write that down for her?
I am, Judge.
Extension 228. You can talk to Heather and she'll tell him how to go about getting this. Okay?
Thank you so much, sir.
Good luck. Thank you.
Thank you.
Thanks, Jamie. And
All right, I will continue to keep an eye on McNally's court because Hoarder Man is still sitting there. But in the meantime, let's go to Texas Judge Stevens.
Do you have something tomorrow? Are you going to be here tomorrow?
Tomorrow, no, not tomorrow. But on Azmaro Bean, that's just I just wanted to go on. She's in Florida. And if y'all just.
I got something for Little Langston.
Oh.
And But I'll have it in the morning. Is this boring you?
I didn't say anything.
Yeah, no, you're sighing.
Yeah.
You're sighing? Are you sighing?
Tired, right, yeah.
Yeah. Well, quit sighing. Do it outside, all right?
I don't want to just inform of it.
I know this is bothering you, but let me just say,
I didn't
be
say
quiet,
anything.
sir. I will speak. See, the rules don't apply to you, do they? You've already been convicted of squeezing somebody's neck, assaulting a family member.
No,
You were convicted in 2006.
that wasn't a family member. It was not.
I'm sorry, it's assault on a family member.
That was not related to James McCain.
Let me see the prior conviction, please. It's in the indictment. The grand jury is wrong. Looking at an adjudication of guilt in 85552, which is the allegation in paragraph 2 of this third-degree felony of assault on a family member that you're charged with, which alleges that in the 252nd District Court next door, you were convicted of assault on a family member on February 24th, 2006 in 85552. Strangely enough, I'm looking at the judgment which says exactly that. You were placed on probation in that case on May 15th of 2002, 6 years deferred or unadjudicated probation, and the judge revoked that probation February 24th, 2006, exactly like this indictment states, and sentenced you to 3 years in prison. You're going to look me in the eye and say you weren't convicted of assault on a family member when this document says you were?
I was violated for technicality.
What is violated? Who violated you?
The
You
judge.
violated your probation.
Because I was behind in my probation fees. I never did receive a PRT.
Once again, were you finally convicted by that judge and was your probation revoked?
My probation was.
And
revoked.
you were finally convicted?
Well, I don't even understand the system, so I felt like.
You know what? It's real
I
easy
didn't
to
receive-
figure out.
I didn't receive a fair,
Yeah, it's easy to figure out. But you came in and just earlier falsely told me that you were convicted, and there's the document that says you were.
but that case has nothing.
That has nothing to do with what?
What I'm in here for.
Yes, it does, because prior convictions enhance and elevate the punishment when you subsequently commit crimes. It's never in the past, sir.
Well, I was falsely accused because the guy.
You know what?
assaulted
You were
me.
convicted by
He
law.
was not my family member. He was not a family.
You were
not-
convicted
we were
by
not
law.
Related in no way, shape, form, or fashion.
Are you finished? You were convicted. And when you look at me and say you weren't, you were lying to me. There's the document on the law that says you were. Which means this third-degree felony that you're charged with, which is similarly a crime against a family member. And you choked this person.
Yes,
When you choke somebody, there's only one reason. You're trying to kill.
that's not my family member. She's.
When I finish speaking, you get a chance to speak, Mr. Interrupter. You see, the rules don't follow. The rules of decorum don't follow with you. You don't believe in the law right here,
No.
and you interrupt.
Excuse me, sir.
Sir,
Excuse me, sir.
don't speak
Okay.
until I'm through. She can't take both of us speaking. But you are just Mr. Rude from the beginning. You were rude from the beginning. You're defiant from the beginning. It's just like a child.
Yes, sir. I apologize.
It's just like a child. let's start acting like adults. What this means is this new case of choking, squeezing somebody's neck, which is a third-degree felony if convicted. This prior conviction in 2006 bumps this up from a third-degree felony to a second-degree felony. So in spite of the fact you want to play it down and it's not important, it changes the punishment range in your case from a third-degree felony up to 10 years in prison to now you're looking up to 20 years in prison. Plus, you're not eligible for probation because you have a prior felony conviction. I consider that important and serious to deal with. But if that were the only thing, you got another third-degree felony charged in the stalking case in 25 CR 866. And then this 867 is the assault. So you're looking at, on this stalking case, this says it occurred on or about May 7th of 25. Is the state going to re-indict that to allege this prior conviction in 85552?
I don't know yet, Judge. Since the complainant in both of these cases is deceased, I know I can prove the assault family violence. I gotta look at the stalking to make sure. If I can, I probably will either that or give a notice of enhancement. That's all we need to do to enhance it.
Right now, this other case of stalking, you're facing a third-degree felony, up to 10 years in prison. So both of these, you're looking at up to 30 years in prison, and you're not eligible for probation. John, what are we going to do today?
Your Honor, this is an issue that he's on a GPS monitor. One of the issues was to protect and keep the victim safe. However, the victim, like Mr. Laird said, is now deceased. So we are arguing and feel that it's not a GPS is not needed for that reason anymore. And so we can just return it back to normal conditions of bond and then keep moving forward with the case. But with no GPS, it's become financially burdensome to do that. And the need for it has now gone away.
We'll say so.
As far as the complainant is concerned, yes, the need has gone away, but safety of the public is also concerned, and he does have a prior for committing this on another person. So I worry about anybody else he comes in contact with that we don't know where he is and can't prove that it's him right away. So
Your Honor, my counter to that is that when it was a victim, it was easy. It was good to have the GPS because we could show if he was going around her or where she was. But as far as a GPS protecting the public, it doesn't do anything for the public. I mean, he still has a right to go wherever he wants to go within limits, but we're not restricting him about being near somebody. We can't say stay away from everyone, and we can't control whether he commits another crime against another person. I mean, GPS monitor is not going to prevent that, do anything about that. When it was a victim in the case, it had its purpose, but now it doesn't have that purpose anymore.
but it does make a person know that they're being monitored to where they're at. So it keeps them at least from committing further crimes, knowing they've got a monitor on. It's up to the court.
Certainly is.
Yes, I'm just making my argument, but
yeah, I just think that whether I mean, if he commits another crime, he knows he can get in trouble no matter what, whether GPS or not. If he walks into Dillard's and commits a crime, people are going to know he's in Dillard's. GPS is not going to do anything to stop that or to help that or to do anything with that.
GPS has its importance in certain kinds of cases.
Like I said, Your Honor, I don't think it has a reason in this case now. It did before the victim passed away. It absolutely had a reason, but now it doesn't have a reason. And he hasn't missed court. I know there's another reason we use GPS to make sure people come to court. He's come to court.
Yeah, okay. He sent a letter to me. Everybody gets a copy. When you back in September a year ago, everybody gets a copy.
I have a copy of it, Jeff.
Okay. I've never ordered a GPS on situation like circumstances like this. And I don't understand how, what's fair is fair. If I did it here in this case, I mean, we're really curious about the whereabouts of everybody that's on bond, but I'm not, that opens a door.
And I think it was originally ordered in this case because it was a stalking case and we wanted to make sure he wasn't on the victim. How did
the lady pass?
Unrelated, it was.
There was a shooting at an apartment complex and she was an innocent bystander, got caught in the crossfire.
A sad thing, but it had nothing to do with this case.
Sounds like last case, last trial.
Yeah.
But yeah, I don't see what GPS device is necessary.
Not now.
Under this circumstance. But you do have conditions of bond, which are.
Oh, sure, absolutely.
Normal and customary for everybody, like don't commit another crime. Because that'll get you.
Yeah.
Right now you're looking at something that's serious enough. You don't need to add to it. But okay. The next thing is, these are indictments a year ago. So what are we going to do?
I believe it was set for and already set towards the trial's out.
Hey, is this set for trial already? The DA's office?
Yes, sir.
When is the docket, please?
I don't know when the date is, but I know it was set for trial already.
Are y'all able to recover that video? Or is that one?
Yeah, we'll be able to recover by the time we get trial. It's easy.
Okay.
It's not that big a deal.
So set for trial.
Seems necessary now.
August, right?
Yeah.
August, okay, all right. Get a resetting there. That's what we're gonna do.
Getting ready to enter hour 3 of TCF Live. Good to have you all here. So it's kind of a spicy morning. And I think it might get spicier. I'm going to take us to Judge Boyd. So this is a hearing that started a little over 30 minutes ago. I'm going to pick it up at the beginning. Every time I glance up, somebody seems angry and spicy and confrontational. And so I don't know how long this thing is going to run. We have an hour left. We're still waiting for Hoarder Man's return as well. We may go long today. We will see. But let's see what's going on here with Judge Boyd.
Yes, Your Honor. All right, Mr. Gonzalez, did you have a chance to review the motion to revoke community supervision and state's motion to supplement pending motion to revoke probation with your attorney? Did you understand it?
Yes, Your Honor.
Right. And counsel, you were recently appointed to represent Mr. Gonzalez.
Yes, Judge.
Do you waive notice?
Yes, we're prepared to proceed. And I've conferred with my client. He's prepared to proceed as well.
Right, thank you. And are you the same Adam Gonzalez who was placed on community supervision in 2023 CR 10135 for the offense of unlawful possession of a firearm by a felon on April 1st, 2024? Is that you?
Yes, Your Honor.
All right, state, what allegations are you proceeding on?
We're proceeding on the original motion to revoke community supervision violation of condition number 1.
No, I mean, just if you'll tell me all the allegations. So it's 1 and what else?
1, and then off of the supplemental, both number 4. Everybody tries to prove today.
All right, so you're waiving 2, 2, 14F and 25?
Oh, I'm sorry, and 25. We're trying to think back on my apologies. We're going to waive both of the 2s and we're going to waive 14F.
All right, any objections to the waivers of 2, 2, and 14F?
No.
And to the violations that are in the motions to revoke, you've had a chance to review those with your attorney?
Yes, Your Honor.
All right, then to violation of condition number 1, number 25, 4, and 4, how do you plead, true or not true?
Not true.
All right, then state you're ready to proceed.
Yes, Your Honor.
All right, state you can call your first witness.
Your at this time, state calls Mr. Rolando Andrade.
All right, and both parties agreed that they would have no objections to the witnesses appearing by Zoom, is that correct?
Oh, yes, Your Honor. That's correct.
All right, Mr. Andrade, I'm sorry, Officer Andrade, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. And if you'll state your name for the record.
Rolando Andrade.
All right, state you may proceed.
Thank you, Your Honor. Good morning, Officer Andrade. I know you probably can't see me very well, but can you hear me okay?
Yes, sir, I can.
Okay, perfect. Officer Andrade, can you tell the court how you are employed?
I'm employed with the Adult Probation Office in Bexar County.
And sir, how long have you been in that position?
I've been with the department for 10 years.
What's your current position with the department?
I am a supervisor at the main location over Central 1.
Okay. And through that position, sir, did you happen to review a file involving an Adam Gonzalez?
Yes, I did.
And how did you go about getting that file in your possession?
I was notified of the probationer's arrest. I reviewed the file on 4/20/2026.
And in reviewing the file on 4/20/26, what were your findings?
Objection, that calls for hearsay.
Sustain.
Okay. Officer Andrade, when you came into possession of that file in April of 2026, to your knowledge, had the victim, had Mr. Gonzalez been reporting to probation as he was required to?
Call for hearsay unless he was supposed to report to him.
All right, that'll be sustained.
Mr. Andrade, when you got the file at that point, was Mr. Gonzalez supposed to report to you?
Objection. May I take the victim on the witness on board IR?
Just 1 second. The objection to that question will be overruled because I believe his question was whether or not Mr. Gonzalez had to report to him.
To him, correct.
Yes.
May I take him on board IR? The witness.
No, I mean that there's no objection. The court is overruling that objection to that specific question. You may proceed.
You can answer the question, Officer Andrade.
No, he was not supposed to report to me.
Who was he supposed to report to at that time?
Another officer, Miss Mata.
Okay. To your knowledge, is Miss Mata available with the department?
She's currently on medical leave right now.
Okay. So what happened to the file then if Miss Mata became unavailable?
I was to review it once if someone gets arrested on her caseload.
And if Miss Mata became unavailable, who was Mr. Gonzalez supposed to report to?
To the probation department.
Was there anyone in particular in the probation department, if Miss Mata was not available, that he was supposed to report to?
That'll call for hearsay or speculation unless he knows what Mr. Gonzalez was told at the time he wasn't Mr. Gonzalez's officer.
All right, the court will overrule that objection.
You can answer the question, officer.
It would be me.
And Officer Andrade, do you know if Mr. Gonzalez was made aware that he was supposed to report to you at that time then?
Objection, that'll call for hearsay.
That will be sustained.
Did you, Officer Andrade, notify Mr. Gonzalez at that point in time that he was supposed to be reporting to you?
No, because he was currently incarcerated.
Well, at what point did he become incarcerated?
He was arrested on April 14th, 2026.
Okay. Prior to that, had he reported, or excuse me, strike that question. Prior to that, when was the last time he reported?
Objection, that's going to call for hearsay unless he has personal knowledge.
Sustained.
Had he reported to you prior to him being incarcerated?
No, sir.
Had he reported to you at any point in time after he became incarcerated?
No, sir.
And what was the date again? I'm sorry, for the date of his incarceration?
4/14/26.
4/14/26. Okay. And it wasn't until then that you became involved in the case, correct?
On 4/20, yes, sir.
All right.
2026.
Since that day, has he reported it all to probation?
No, sir.
To you directly?
No, sir.
Okay. I'll pass the witness, Your Honor.
Does probation have a policy for people reporting while they're in jail? I mean, in other words, do they have a free number they can call to talk to probation?
They can call the officer. Yes, sir. They can call the
Is there-
main number from the jail.
Is there a free call? If he doesn't have the funds, is there a way for them to call the officer for free? Do y'all have some kind of setup with the jail so people can report while they're in jail?
No, sir.
How many people you've been in 10 years, in your 10 years, how many people have reported in jail?
Very few.
That's because one, you're not going to take their call. You're not going to pay for their call, their collect call, are you?
No, sir.
And then secondly, he was arrested April the 16th and you never touched this case until April the 20th. Is that correct?
Yes, sir.
So how would he even know your name to call you on April the 20th or April 16th and beyond? Did you take the time? As I understand geographically, your office is what, across the street from the jail?
Yes, sir.
And I know you're seated now, but are you ambulatory? I mean, can you get up and walk?
Yes, sir.
Okay, so if you had to get up and walk and you were physically able to, how long is the walk from your office to the jail? What, like 2 minutes? 1 minute?
Yes, sir. Yes,
Okay,
sir.
so how many times did you walk over there to let him know, hey, even though I'm not going to take your call, you should try to call me?
0.
Okay, that's all I have, Judge.
Any further questions?
No further questions for this witness. You may be excused.
All right, thank you for coming in by Zoom, Officer Andrade, and coming to be in person in court as well previously. You
No
may be
problem.
excused. Thank you.
Thank you.
All right, who's your next witness?
Your Honor, at this time, state calls Eliza Acosta.
All right, thank you for appearing by Zoom. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name for the record.
My name's Elisa Acosta.
All right, if at any time you're unable to hear the questions, just let me know. All
Yes,
right,
ma'am.
state you may proceed.
Thank you, Your Honor. Good morning, Mr. Acosta. I know you probably can't see me, but can you hear me?
Yes, sir.
Okay, thank you. Good morning, Mr. Acosta. Mr. Acosta, do you know someone by the name of Adam Gonzalez?
Yes, sir.
How do you know him?
I've known him for 23 years. Him and I shared 2 kids together. We were in a relationship for 10 of those years.
What kind of a relationship was it?
It was considered common law. We did get married. We never finalized our marriage certificate because he ended up getting incarcerated.
Okay, do you remember what time you guys attempted to do that?
That was July 15th. It was probably 7 years ago.
Okay.
That happened a long.
How would you characterize your relationship with Mr. Gonzalez?
It was abusive. It was physically and mentally and verbally abusive.
And was he abusive to you on January the 23rd of 2025?
Yes, sir.
Can you please describe to the court how that day began?
Yes. So we had previously separated. We ended up moving in together. I needed some help with his kids. We were staying at an apartment.
Do you know where that apartment was located, Ms. Acosta?
I don't know the physical address, but I can get it. But it was the flats on Vance Jackson and Jackson Keller.
To your knowledge, Ms. Acosta, is that apartment complex located here within Bexar County, Texas?
Yes, sir.
Okay, and go ahead and continue. What happened when you arrived at the apartment complex?
I had showed up to go and collect my belongings. I was going to leave the apartment because of all the abuse. I showed up in the morning, knocked. He opened the door. I was alone. When I walked into the apartment, there was a bunch of electronics everywhere.
What kind of electronics did you see?
Soundbar, TVs, speakers, laptops.
All right. And what happened after you saw those electronics?
I confronted him about the electronics because how did he have money to get all these electronics overnight when we were there and the kids and I were starving? We had no money. So what are you doing? So that turned into an argument because I questioned about where all these items came from.
Okay, and what happened after you guys got into an argument?
It got physical. We were in the living room. He pushed me onto a futon that we had. When I stood up, he grabbed a decorative table that we had and swung it at me and hit me in my left arm.
And what happened after he hit you with that table on your left arm?
I tried to make it to the door. He grabbed me from the back. When he grabbed me, there was a desk. I'm sorry. There was a desk by the front door. There was a screwdriver on that table. I grabbed the screwdriver and I turned to try to stab him with it.
Why did you feel the need to do that, Ms. Acosta?
Because he was attacking me. I was trying to get out the front door. He stopped me. He pulled me back. And at that point, I couldn't even move my left arm. I wasn't sure if it was broke or not. It was just, I couldn't move it. It was just completely in pain.
Okay. And what happened after you attempted to stab him with that screwdriver?
I made contact. It broke a little skin. It was his right arm, right above his elbow is where I stabbed him. I stabbed him. He ran out the door and I started screaming for help. I didn't have a phone. I was screaming to the neighbors. Nobody heard. So then I ran around the corner to 7-Eleven and borrowed their phone to call 911.
Were you able to contact the police at that point?
I was, and then I made it back to the apartment. I found another neighbor outside. I asked to use their phone as well because the cops had not showed up. And then at that point, SAPD and Castle Hill showed up.
Okay. If you give me 1 second, Mr. Costa.
That's fine. No, of course. Yeah.
Mr. Costa, I'm gonna try and do this a little bit differently. And tell me, can you see me right now, Mr. Costa? Okay. Now, I'm showing you what has been pre-marked as Exhibit 1 for identification purposes. Do you recognize what this is?
Yes, sir.
What is this, Mr. Costa?
That's the decorative table he hit me with. Excuse me. That's a decorative table he hit me with. It was
How do you know that it is the table in particular?
That was our table we had in our living room. If you flipped it upside down, there's a mirror on the other side. That's the side I got hit with, the bigger side of it, because he picked it up and had it more towards the bottom carrying it.
Okay. Have you seen this before?
Yes.
And then lastly, Ms. Acosta, to your knowledge, has what's in this photograph been altered in any way?
No, no, sir.
Thank you. Ms. Acosta, I'm now showing with an pre-marked exhibit number 2 for identification purposes. Can you see this?
Yes, sir.
Do you recognize what this is?
Yes, sir.
What is this?
That's my left arm where he hit me. It's right above my elbow.
What's depicted on this picture, Ms. Acosta?
It's a bruise. I got an instant bruise and mark.
Okay. To your knowledge, Ms. Acosta, has this photograph been altered in any way?
No, sir.
Thank you. Mr. Costa, I'm showing it to pre-marked exhibit number 3 for identification purposes. Do you recognize this?
Yes, sir.
What is this picture of?
My left arm as well. Right above my is
And
where
what's depicted in this picture?
the bruising and the markings where I was hit.
To your knowledge, Mr. Costa, has this photograph been altered in any way?
No, sir.
Thank you. And lastly, Mr. Costa, I'm showing you this in pre-marked exhibit number 4 for identification purposes. Do you recognize this photograph?
Yes, sir.
What's in this photograph, please, Mr. Costa?
My arm as well.
What's depicted in this picture?
The same thing, the bruising to my left arm.
And to your knowledge, Mr. Costa, has this photograph been altered in any way?
No, sir.
Your Honor, at this time, we will offer into evidence exhibits 1, 2, 3, and 4, and we'll turn it to defense for any objection.
Norma? Mr. Vaccaro, do you know, I'm sorry, out the record for a moment. Do you know, is your attorney in jury trial?
Yeah, I called them earlier this day.
So they're actually in trial now?
I called the office.
If you would like, I have the attorney's number. I can text her.
Yeah, if you could text her, because I'm going to try to get you out here as soon as possible if they're in trial. And the reason why I called you back today, because sometimes attorneys are up for trial, but they actually don't go. So I'm trying to get you out as quickly as possible. Are you going to have any objections? Oh, no objections.
All right, so
All right, Cindy, states exhibits 1 through 4 are admitted without objection.
may the state publish the reports.
Yes, thank you. Thanks for texting them, Rick.
You're on, Trish. Okay, I just checked, there was the response to it.
All right, thank you.
Ms. Acosta, did anything else happen after you made contact with the police?
I think we may have lost her.
Oh, no. Guess we want to step back and try and get her
Yes.
back on and then you pick the cases we need to.
Okay, sure. Anyone else ready? Yes. All right, Jesse Alvarez. Oh. So this takes care of the cases. Now, Mr. Alvarez, they're dismissing the case for insufficient evidence. But just so you know, you're not allowed to have any type of weapons. You're not allowed to be in vehicles with weapons, because your attorney will tell you, if you're in a vehicle, if you're just the passenger, if there's a gun within your reach, that's considered care, custody, and control, whether it's your gun or not. You understand? All right, good luck to you. Thank you. Anyone else ready? Anyone else ready?
I think we may be ready in a few minutes on another case subject to custom state.
All right, thank you.
Robert.
Okay, again, we are about 30 minutes on the way back machine, so I'm going to try to bump us forward. They'd lost contact with the person they were, there we go. So, I know this is a little bit heavy for some of you, but I think these cases are important to look at, because we need to know what's going on out there in the world, how people are treating each other. All right, let's get back to it.
I'm so sorry.
No, no problem. It happens. All right.
Yes, Ms. Acosta, my question for you is, did anything else happen after you came into contact with the police that day?
Yes, sir. I wasn't sure. Do you mean between Mr. Gonzalez and I, or with the cop?
With Mr. Gonzalez?
No, at that point he was gone. He left. He never returned.
Okay. I'll pass the witness at this time, Your Honor.
Thank you. All right, so let's start at the beginning. Who's David Hernandez?
David Hernandez is the father of my first 2 children.
And is that where you were living? Were you living with him on Parent Vital?
No, I was living with Adam at the apartments.
At whose apartment is that?
It was Adam's friend. He was basically, I guess, subleasing it. It was not on the lease or anything.
Now, in the picture, you said you went over there to get your stuff. In the pictures the police showed me, There's no women's stuff anywhere visible. So
Well, that's the living room. If you went to the bedroom, you would see my kids' bunk beds, my kids' toys. We shared 2 dogs. Him and I were physically living together in that apartment since November 1st.
since
I lived there
November the
3
1st.
months and endured 3 months of abuse. And there was several police records to prove
I know
that.
you don't like him. I know you don't like him, and I've read your text how you're going to fuck him up with the DAs, and you're going to talk to another DA if the first one doesn't get it done. I've read all the text. I know you don't like him. You don't have to stress that part. Now, so you're saying you moved in that apartment in November?
Yes, sir.
You lived there full time?
Yes, sir. My kids
Okay.
as well. His kids as well. He can vouch for that.
I'm asking you questions right now. So you said on this day, you got there alone.
Yes, sir.
So your kids were inside?
They were in the school, and the police officers sent the kids to the school when this incident happened to make sure Adam Gonzalez wouldn't pick the kids up.
No, that's my question is when you
I
got
was
when
alone.
you right, and your kids had not spent the night there, had they?
No, not that night. We were
Okay,
not
so
there
where
that
had
night.
your kids spent the night? Ironically, with David Hernandez on Parent Vital, or where?
Why do you need to know where my kids were that night if my kids
Told the
weren't
police
involved?
in your 911 call, please get over here. My kids are here, and that's a lie.
In the 911 call when he assaulted me in that particular
Yes.
incident?
Okay,
In
but your
January.
kids
Okay.
were not there, were they?
I never said that because my kids were in school, but that's fine. I never said that in my
Now, you also haven't mentioned to the judge in your testimony about how what really pissed you off is you found a box of condoms. Remember that?
Yes, sir.
That's what set you off, isn't it? You found a box of condoms and you said something like, we don't use those, so why do you need these?
No, sir. I was upset by the electronics because you have to understand, like I said earlier, we were starving, my kids and I.
Right.
We had no money. So where did he come and get all these electronics?
Well, so why did you tell the police that's what started it was you found the box of condoms?
Because
So
that
either
was a
that's
part
what
of as
started it
well.
or that's not what started it.
Okay, the condoms is a part of it, but the electronics as well. Because the first thing when I walked into the house was the electronics, not the condoms. The condoms weren't thrown all over the house. And if you
Where
can
did
see
you
the picture, they weren't on the floor in the living room.
They were. The box of condoms is on the floor in the living room, yes. But
It was in the restroom under the sink because that's where I went to get my straightener from.
that's where you found them and then you threw them somewhere else because the picture shows them on the floor in the living room. But, okay. Did you not look at the pictures with the state when you were here?
Yeah, but I was looking at the table I got hit with, not the condoms.
Okay. Well, the condoms are what started this whole thing.
No, it's not. It was a part of it, sir.
Okay. Now, where did you spend the night If you lived with the apartment and your kids live at the apartment and their beds are at the apartment and your clothes and your straightener are at the apartment, but now you're saying, but the night before you did not live there. You had not spent the night there with your kids the night before.
The day before, I got picked up the day before because I had been enduring abuse those 3 months and starvation. So I called and I got picked up. I said, I need out. I want out.
So where did you spend the night before?
I stayed that particular day. I got picked up by David and I stayed with David and my other 2 kids.
So when I asked you if you stayed with David at Parent Vital and you said absolutely
No,
not.
you said, do I live there? And I said, no.
Okay.
So that was the question. And I answered correctly.
So that was the first time you had talked to David in how long?
3 months.
You had not talked to your ex in 3 months.
I didn't have a cell phone. No, sir.
Okay. Now, the screwdriver you said was on a table by the door?
A desk by the door.
It wasn't in the toolkit that was opened that the pictures show?
No, that's not a toolkit. He kept all his tattoo stuff in there. There was no tools actually in there. It's a toolbox, but it was for tattoo stuff.
Now, you also you said you stabbed him, right?
Yes, sir.
In the arm with the screwdriver.
Yes, sir.
As you're running out the door to get away from him, you stop.
No,
grab the
he stopped.
screwdriver. Let me finish, okay?
Okay.
You're going to the door, right? You're headed out, right? Because you found the box of condoms. You're mad. You're leaving. You keep shaking your head no, but you told the police that. Have you read the police report? Did they go to the trouble to have you read this?
No, I know what I said, but go ahead, continue.
Well, so you're at the door leaving, and you stop and get a screwdriver and turn around to confront him. That's what you're saying today, right?
Can I talk now?
Sure.
Okay. So I did not stop. I said he stopped me. So when I'm running and he grabs me from the back, yeah, that's going to stop me. I weigh 100 pounds. He weighs, at the time he was weighing 200. So yes, I was stopped. So when he stops me, I'm going to throw my hand out and reach for whatever I can grab. And that's what I grabbed.
Now, that's different than what you told the police today. So I know you keep rolling your eyes, and maybe they'll call a police officer to straighten this out. But
No,
you told
it's just because I went through this, and it's like, let's not make it less than what it is. Validate my feelings and what happened.
I read what you want to do. You're going to make sure some DA listens to you. Fuck this. Fuck him. I'm going to make sure he pays. I know what
because what he did to my kids. Do you know what that was? You don't know. You didn't endure it. My kids did.
Well, we're not here for that. Okay. So
yeah.
if something happened, you apparently know a lot of DAs, so call one of them.
That's fine.
Okay?
That's fine.
Okay. But on this day, even though you told the police on 911 your kids were there, they weren't, right?
My kids were at school. I never said that my kids were there. You probably have a different 911 call because my kids were there at other times.
You said, so you had a key to the apartment?
Yes. We lived there, him and I.
But that's just, did you have a key?
Yes. Yes, sir.
And when did you get the key?
When I moved in November.
November? Okay.
Yep. November 1st is when I went into that apartment and we took all our belongings, 2 kids and 2 dogs.
November 1st of what year?
Last year.
2025.
Of the same year the incident occurred. So, the year before. So November of 25.
Okay, well, I'm going to help you.
24.
The offense date, according to this happened on January 23rd of 2025, right?
I will tell you right now. Of 25, yes. So I moved in November 24.
And you're sure of that?
Yes, sir. That's where we lived.
Okay, well, the problem with that is
to get to school, we took them to school from there.
This is his lease for that apartment?
It was not in his name.
No. I know that. But this is the lease for that apartment. Right?
Okay, I don't know. I've never seen it.
Well, I'm telling you, I'll let you see it. If you were here, I'll show it to you right here. You want to see it? See where it says lease and his name's on it?
I can't see that. So
now mark this as defense 1.
Could I ask what other residents are listed on that lease? Because I know the person that lived there with their son. So was there 3 individuals on that lease, or is it
just one moment? Are you all in jury trial?
Judge Castro's not calling to the bench yet. Apparently it's us and a CT case with the defendant in jail, so we're just waiting.
Okay, all right, thank you. All right, you guys may continue. Sorry about that.
Okay, I'm going to try to put it real close. And look on the top, you see where it says the name of the person on the lease. Can you read that?
Michael Ramos.
Okay, and then he has a child named Michael Ramos Jr., right?
Okay.
Okay, so in this apartment,
name on there.
If this lease says 2500 Jackson Keller, apartment 1205.
Yes.
Your testimony under oath, and you're as sure about that as you are what this other story you've told us today. You moved in there November of 2024.
Yes.
Okay, can you explain to me how he signed his lease on January the 8th of 2025? So how are you living in an apartment he didn't even have?
Because he was subleasing it to us. He moved out.
Michael Ramos.
Yes.
Right. Michael didn't have the apartment until January the 8th.
He renewed his lease. He had lived there for like 11 years.
Okay. It shows that's when he moved in, January the 8th.
Okay, no, he's lived there for 11 years. His child went to Jackson Middle School behind. We would babysit his son after he got out of school. Like, let's be real now.
Oh, I'm real. Just as real as your threats are.
Yeah.
I'm real. And as much as you stabbed. Now, let's go back to you stabbing him in the arm.
Let's go.
Now, you told the police when he picked up the table, you stabbed him in the arm.
No, he hit me with the table first.
So that's changed since that.
I got hit and then I got stabbed. Okay. I am sorry that I have endured PTSD. I have depression because before this incident, I had an AK to my head. So I'm sorry if my story doesn't align word for word with the police report, but this happened.
Something happened. You broke in through the window of the bedroom.
I broke
You
into
came
a
in,
window
You
now?
woke him up. You found the condoms. You got mad and you attacked him. And then
So
you
how did
took-
I get hit with the table? Because I attacked him, so he was protecting himself? Is that what we're saying now? So where's the police report from Mr. Gonzalez about me attacking him? Why didn't he at any point ever call the cops, since he's the only person in that apartment that had a phone? Huh? Did I hold him down and not let him call for help?
I don't know what you did after you stabbed him. I truly don't know. I know he left, so because to avoid any confrontation with you, because
he had already broke my arm.
And you do know that you're so scared of him, but he had to call probation in August and report that you would not quit harassing him and threatening him. And that's in his probation file. Do you know that? Yes or no?
No, I don't. No, I don't.
Okay.
I don't understand how I was scaring him with no phone, but that's fine. Do we have all the reports where I called Miss Mata and reported where he was abusing me and beating me up? Do we have all those reports?
We don't have Miss Mata.
Oh, okay. But we don't have the reports either. But we have your report where he reported,
Police report.
harassment.
Not my report.
Okay.
Okay. Actually, it's their report.
Yeah.
Okay. So now you also, what happened to the electronics? Did you take them?
They were all broken. He broke them during the argument.
Because in the TV, I mean, the pictures that one of the TVs is still, you said there were two TVs, two sound bars, but there's only one TV in the
I
picture.
didn't say the number. I said that there was TVs, sound bars, laptops. I said electronics. I never specified a number. So yes, I used TVs with more than one, that means more than one, but I didn't say a few, a couple. I did not specify, sir. I just said there was TVs.
All right, everyone, just one moment, please.
Alrighty, again, we're a couple minutes in the Wayback Machine here, so we will try to bump forward through this little break here. Alright, there we go.
Mr. Costa, are you able to unmute?
Yes, sir.
All right. Now, Ms. Acosta, I have one last question for you. Looking at your screen right now, do you see Adam Gonzalez?
Yes.
Can you identify him by an article of clothing that he's wearing?
He's wearing orange.
Thank you, Your Honor. No further questions.
So, Miss, any of
Nothing further. No, please. Go ahead.
So here's my question. It's not really a question, but I want to let you know that I had ordered that there was to be no contact. And I understand that sometimes people think relationships, maybe they will end up working out. But I put the no contact order in place to make sure that all parties are protected. So I'm going to place him on full GPS, which means he's not going to be allowed to leave his home. And you're not going to have any contact with him. All right, so this is what the court is going to do. The court is finding violations 4 and 4 not true. The court will find violation of condition number 1 not true. The court will find the condition number 5 true. I'm sorry, 25, thank you. Court will find 25 true. This is what the court is going to do. Come forward, sir. Sir,
Oh, I'm sorry. We were talking. I'm sorry. My apologies. Front center.
I don't know what people don't understand when I say no contact.
Yes. Yes,
People
Your
want
Honor.
to do their own thing. That's not allowed. there's no allegation that you had contact in the motion to revoke. So I'm only dealing with what is before me. So
Isn't that what 25 is, right?
25 is inadvertently in contact, which put me, she came over. So the other issue of exactly no contact, because she should not have gone his apartment. I have no jurisdiction over her to make her not do that, but I do have jurisdiction over you. So 4, 4, and 1 not true, 25 true. And the court is gonna alter the main conditions to include the bib course, and there's gonna be full GPS. There's to be no contact with the complainant that was in the violation of condition number 1 and 25. There is to be, I'm gonna order, I think I may have already ordered a parenting class.
I completed the parenting class, Your Honor.
Well, it's not working. So, do a step up on parenting classes. I don't know what would be better for him. Do they still have compadre?
Yes, Your Honor.
All right, so you're gonna do parenting classes with compadre, and there will be no one else, just compadre. The court is not gonna accept parenting classes
Okay.
through anyone else, okay?
Yes, Your Honor. Thank you.
And that's gonna be a full GPS until further notice and waive GPS fees.
Thank you, Your Honor.
And the court will not consider changing that for employment unless you provide proof of employment and a work schedule.
Yes, Your Honor.
And there's to be no contact with her. Do you understand?
Yes, Your Honor.
And there is to be no, and I previously put in here, no unsupervised contact. So there's to be no unsupervised contact with minors. And the court will only reconsider that once you've completed the parenting classes.
Yes, Your Honor.
All right, thank you.
Thank you, Judge. Thank
Your
you.
Honor, how long did you want to give him to get the GPS?
What's the soonest he can have that? I would like it before his release.
Okay.
Mr. Brock, your attorneys, I mean, your client's gonna remain in custody. They do the GPS at the jail.
Correct.
So he's not gonna be released until he has that GPS on.
That's fine,
Okay.
of course.
All right, thank you, Judge.
Okay, thank you. When I talk.
Alrighty, friends, final half hour of TCF Live. So I still have eyes on Judge McNally's court. Hoarder Man continues to sit in the courtroom awaiting to be called. If he pops in before the end of the show, we'll go long. If not, we'll simply start with him tomorrow. But we'll see how it plays out. In the meantime, let's change things up. Let's go to Louisiana, checking on the board this morning.
The Committee on Parole is impaneled at headquarters in Baton Rouge. Today, serving on the panel to my left is Chuck Tillis. To my right is Danny Barra. I'm Jerry Ledoux. I would like for the staff here at headquarters to introduce themselves to the record.
Francis Abbott.
And we are currently at Point Capay Parish Detention Center. Will the staff there introduce themselves?
So there's no staff in here. I'm attorney James Manasseh, and I have Mr. Charlie Smith sitting with me.
Okay, so there's no staff. Thank you. Mr. Smith, you're here before this panel as a violator of your parole conditions. And before we get started, would you introduce yourself with your name and your DOC number?
Can you hear? He's very hard of hearing, and we have this turned up as loud as we can.
Okay.
Okay, so come as close as you can. Give your name and your DOC number. Thank you. Okay. They're asking for your name and your DOC number. Your name and your DOC number.
My name, my DSC number.
Your name first. What's your name?
Charlie Smith.
And your DOC number from when you were in prison. Your DOC number?
78665. When I was in prison.
You should have a parole questionnaire, and it's a formality because you do have counsel with you. But did he complete his parole questionnaire?
Yes, ma'am, we did that previously.
Okay, thank you very much. You do have Jimmy Manassa, your attorney is present, and he will assist you as we go through the process. I'm going to read some violations against you, Mr. Smith, and I'm going to need you to say if you're guilty, guilty with a statement, or not guilty. On 3/4/26, March of this year, you were involved in criminal activity because you had 3 firearms, 3 counts of having a firearm by a convicted felon, and you were arrested. How do you plead to that?
How did you plead the firearms? Not guilty?
Well, even if I
Yeah.
not guilty, they wasn't mine.
The day before, Agent Pouchot observed a rifle inside your pickup truck, and you were the only person in that vehicle. There was also 22 ammunition in the console. The firearms were seized. You are the only occupant of your house. So you have been charged with 3 counts of possession of a firearm by a convicted felon. How do you plead?
How do you plead to the possession of the firearms? The firearms that were there at the car and in the house. How do you plead?
Not guilty, because I didn't know they had them in there. I didn't know. My daughter had bought the trailer.
Hold on.
Okay, number 10, you're currently $4,552 in arrears toward your supervision fee.
You're behind by $4,500 in your supervision fee. Is that true or not? The monies that you owe for supervision.
What is supervision?
For the parole officer supervisor.
So you owe that, but I want to get. I've paid it. Listen, I'm paying it every month.
They right now they just want to know are you behind or not?
God no, because when I paid, the people took the money and then I wouldn't get credit. I went bankrupted paying it. I paid it so long for years and years. They never would come out, and they never would come stand nobody. And for what happened, even the what you call that corona, what you call that shit, they come out.
Let me just he'll plead not guilty at this point.
For the record, I did note that there had been some fees paid that was applied to the wrong account at one point, so there may be some confusion on fees.
Yes, ma'am.
Okay. So, let's let you have the opportunity to.
Well, let me call this guy just to make sure he ain't sending somebody. And if he ain't, then I'll call him.
Staff just walked into the room where we are. That's okay. We're on a parole here. That's okay. I'm sorry. Staff just came in and they're doing something over here on the side. So
Okay.
got to be quiet.
So I would like for Mr. Smith to explain why there were 3 guns in his possession.
Yes, ma'am. You explained why what the guns were doing there. They're asking about the guns. Now it's
They
not
been
getting
in the trailer when they bought the trailer there. I never did prove with no gun. I didn't even know they were in there. They're gone. My daughter bought the trailer from Laviville, full of all kind of stuff. And I was sleeping in the front room up to the front, me and my dog. And I was raising chickens and things. I didn't know all the guns. You know, if I knowed all the guns in there, I'd have been took them out and got rid of them. I ain't know about the trailer. It wasn't my trailer. I was living in it now.
Okay.
His daughter was trying to sign on this morning. Was she able to get on?
I don't see her on our list, no.
They may have said it was going to be 9 o'clock, so I don't know if maybe she's a little behind.
Well, we have the complete record, and I just want to make note that at least 3 times in the last couple of years, Mr. Smith has requested guns, and it's in his record that he's asked for guns several times. And they have found ammo previously, and the gun was found in his truck, and he was the only person in there. So there's no doubt in my mind that he was present with a gun and knew that. So, so I've heard your story that he didn't know, and it's his daughter's. We have Mr. Luke Pucho, who is the PMP agent. If I butchered your last name, I apologize.
Come on.
If you want to speak on this case. So.
Good morning, I'm Luke Pujo with Probation and Parole out of West Baton Rouge Parish. On March the 3rd, I was doing personal contacts in the Maryland area. I went to Mr. Smith's residence, knocked on the door. I heard a dog barking, but there was no one inside. I went back to my state unit, writing down paperwork, and a pickup truck pulled up behind me. I backed my unit out and made contact with the driver. It was Mr. Smith. I noticed 22 ammunition inside of the vehicle, and I was looking, and it appeared to be a rifle inside the truck. So I asked Mr. Smith, I said, since this is my first time meeting you, I'd like to look inside the house. He then pulled his truck back into the driveway, and I was able to walk around on the other side of the pickup truck, and I saw what it was indeed a rifle of some sort. I made contact with him in his house again, saw more ammunition. At that point, I told him, have a good day, and left the scene. I then went down the street and called my supervisor, Mr. Bordelon, and a plan was formulated to search the house the next day to conduct a real compliance check. Myself, along with other agents in the Pointe Parish Sheriff's Office, went to his residence, conducted a compliance check, and the 22 rifle that was inside of his truck was discovered to be an expired bedroom closet. And then I discovered 2 firearms inside of his room that he was sleeping in. One was a .38 special revolver in his nightstand that was loaded with hollow point ammunition. The other was a .22 pistol automatic that was in a box from the manufacturer. It had 3 magazines, and they were all loaded with hollow point ammunition. Mr. Smith was arrested by the sheriff's office and charged.
Thank you, Mr. Pocho, for your testimony today.
Thank you.
While irregular to have someone in support speak after the opposition, I'm going to allow Ms. Paige Smith has just joined us via Zoom, and she would like to make a statement. Mr. Pucho, if you feel like you have to rebut or anything, let me know.
Yes, ma'am.
But Ms. Smith, if you would like to make a statement at this time, you're welcome to.
Hi, good morning. Well, my name is Paige Smith, and I am Charlie Smith's daughter. And at this time, my dad is a 84-year-old man. And I think at the time when he was released, he was not, any issues. He has not. I've been with him for about 12 years since he's been released. And as far as the guns, I mean, I'm not sure exactly where they came from, or if he's even aware that he wasn't supposed to have them, if he was even still on parole. But as far as the family, I mean, I know his health and his mental capacity has declined, as most 85-year-old, people. And so at this point, we are aware that, this was a huge oversight, and we're prepared to, rectify that with him, where there's additional supervision, possibly even him having to stay with me so we can look after him if he can no longer, make decisions for himself, and his mental state, is compromised. And so at this time, I mean, the family has supported him and will continue to support him. And it's difficult to comprehend that, your parents' mental state has declined. If you ask them, are you okay? They may say, oh, yeah, I'm fine. And they may forget something. But for you to truly understand that their mental state is no longer there, whether it's the onset of dementia or whatever the case is, it's a tough pill to swallow. And with this situation erupting, coming to a head like this, it's on the forefront. And now it's not, it's not whether or not it's depreciating, but yeah, at what speed now has it depreciated? And now what steps do we need to take so he can live out the rest of his life, humanely? So,
Ms. Smith, let me ask you, where do you reside? Where do you live?
I live in Ascension Parish, which is in Prairieville. So it's about 58 minutes from Maringouin.
And do I understand you to say that you are willing to provide housing to your father?
That is correct.
For long term?
That is correct.
Okay.
I have a 4-bedroom. My oldest has gone off to grad school. So I have an empty room now. So he's more than welcome for me I can house him.
Okay.
Can I ask a question?
Yes, you may.
The trailer, who bought the trailer?
I purchased the trailer for him.
Okay, how long have you had it?
Maybe 5 or 6 years.
So you had no
That's it.
knowledge of guns being in there?
No, I did not. I did not buy it brand new. It was a used trailer that I did get out of Lafayette, Louisiana. And I just paid for all the transportation and, to have it.
Yeah, how often do you visit him or check on him? Your family members, how often do y'all go over and check on him?
On him? Yeah, well, prior to this incident, I would go weekly or sometimes twice a week. So for example, he can't read or write, so I'll make sure I check the mail. I may go on a Wednesday, and then I'll bring the kids on the weekend to do like cleaning. I may stop at Sam's, get groceries. So it's ongoing. And so I would check, but I didn't know that was going on to check for that.
How do you think he's going to react if he has to live with you?
I mean, I think like most elderly people, they wouldn't want to, but we make those decisions based on their welfare and their, So I think in this case, it would be an adjustment and a transition for him. And I would transition his animals and, start to let him acknowledge, because at one point I did live with my dad. When I purchased the trailer for him, I lived with him for about 3 months. And then I slowly transitioned into my home. And so I didn't abruptly leave. I, still come and go so he wouldn't, have that shock.
So you were the only one checking on him?
No, he does have a sister in California that would call him morning and evening. He has additional family members that resides in Maringouin. They're about 5 miles from where he is. And so a lot of the times, if you call someone, hey, how are you doing? They're not going to tell you if they're in distress or if, they can't remember. But I know there were times when he would call me and he didn't know who I was, or, he'd ask me, who am I talking with? And so you would start to see those telltale signs. And I mean,
Okay, thank you.
I would like to request to go into executive session.
I'll second. Yes.
Borough,
Yes.
Liddell,
Yes.
Tillis.
Yes.
Okie dokie, friends. Well, they do executive session-y things. real quick, after this hearing, we will go to Hoarder Man, so we'll run long to get that in. But there was a question about competency in the chat, so I looked it up with regards to Louisiana and the parole board, whether or not competency was a requirement. And the reason why I looked is that a parole hearing is an administrative proceeding. It is not adversarial. So I was curious if there's the same requirements, and there's not. There is no requirement in Louisiana law that the inmate have any specific level of competency to have one of these hearings or participate in them. Now, that having been said, their level of competency is certainly something that is considered by the board with regards towards what to do with them. So that's a factor. But they do not themselves have to be competent to have one of these hearings or to participate. Hang tight here. Let me get queued up. We were a couple of minutes in the Wayback Machine, so fast forwarding past the executive session. Here we go. Let's get back to it.
Hearing no objection, we'll go ahead and continue with this case of Charles Smith. I will tell you that it's a difficult case because of the time that Mr. Smith is looking at in terms of original sentencing and full-time date. Today, my vote is going to be that Mr. Smith be able to have the detainer lifted and bond out, to go only to his daughter's residence, and then the courts can take care of the legal issue that's before the court. And Mr. Smith is not to return to Point Capee Parish during this time of supervision. And that's my vote. Mr. Barra? Mr. Tillis?
I concur with Ms. Ledoux and am not to return to Point Capee Parish.
All right. I see it a little different. My vote would be to continue the case without bond and hold him. But I'm outvoted by 2-1, so that's a moot point. But that was my vote, would be to hold him pending the outcome of the charge and let them determine what they were going to do first.
Mr. Manassa,
Yes, ma'am.
I would like for you to explain that to Mr. Smith, and I want to get his acknowledgement that he understands that he has to live with his daughter. I want to see that from my personal.
Yes, ma'am.
Okay, you can do that now.
I'll explain. I have talked with him about this previously, and he wants to live with his daughter, but I will explain it here in front of you.
Please do.
So they will agree to lift the hold and let you come home, but not home where you were living. You can't come back to Point Capee. You're gonna have to go live with your daughter, with Miss Page. Are you okay with that?
Come there to see our check.
Nope, we're gonna have to, that you can't come back. His concern is he was raising chickens and goats and snap peas and that, but I've explained to him that he can't come back.
Okay.
He won't be able to come back. That'll have to be taken care of by family. Okay? Okay.
Okay. So that concludes our hearing with Mr. Smith and our business at Point Capee. It's 9:05 and we're signing out.
Okie dokie, friends. TCF Live going into overtime. We will spend a few minutes back in Judge McNally's court so that we may finish today's episode, anyways, of the Hoarder Man saga.
Member Thomas Boyd.
Mr. Crawford. Michael Mr. Boyd. What are we gonna do with Mr. Boyd? Did you call your son?
Couldn't get hold of me on him. Just connected his phone to the police leads.
He also tried calling his wife, his wife, and she didn't answer because she's at work.
I didn't know you were married.
No, his son's wife.
Oh. What am I gonna do with Mr. Boyd?
Exactly sure, Your Honor. It appears to me that my client is with every sincere effort that he can in these advanced years and the type of support he has.
No, he's not. I've given him too long. They've been after him for 25 years to do this. Mr. Boyd, I think it's time for you to go to jail, and I don't want to do that. Why are you not taking care of this?
I took care of a whole lot.
Do you have the pictures that they had?
I don't have the pictures, Your Honor.
Okay.
Pictures.
Only if she's available.
But Your Honor, my client submits that he did get the bolt removed. He got the trailer.
Yeah, but she just got done telling me he's only done, it's about the only thing he's done that's on the list for him to accomplish when I placed him on probation 11 months ago. And they've been after him for 25 years.
He's out of the way.
I didn't get the opportunity to talk with the prosecution to see if we put our heads together and make other suggestions.
Well, I mean, this has been going.
I know.
He's not going to listen. You're not going to listen to him. I don't think you're being defiant of me in the sense that you're not basically one of these guys that comes in there and thinks he owns the place. But you're not being defiant. You're just, I think there's some issues here.
What the solution is, I don't know.
Well, the solution is probably, I just got to send him to jail, I think.
Well, unfortunately, when you come out, he's gonna be in the same situation.
I know, but they've been after him for 25 years. You know how many hearings I've had him here on? Guys, can I have your name and can you both count your appearance?
Caitlin Fuller Farm, Brownsville Township.
Rob Harris on behalf of Brownsville.
Can you spell your last name for my recorder? You, Ms. Perez.
Harris,
Harris.
Harris.
All right, what are we gonna do? Give me the pictures, please. Let me see them. Did you show them to Mr. Crawford?
Earlier.
I gotta say it
First glance, Your Honor, they looked a lot cleaner than the other pictures that were in the file. You look brighter, you kind of see the property a little bit more. We can,
Did say there's progress, just.
not as much as one would like. So.
He is making progress, though. Maybe a little bit, right? Looks like the Taj Mahal compared to before, even though it's. You got to get the vehicles out of there. These are inoperable vehicles. What's this wood pile doing here in the middle of the yard?
When they stole my wood last fall, I had to buy some more wood. I heat my house with wood. And I didn't want to put it in the backyard because
If I give you 2 more weeks, you're gonna have this done?
how about
Hang on. What do you want me to do? Send him to jail?
I don't know, Your Honor, I know that this has been going on.
I know.
Yeah.
Ad nauseum.
all I've got left is the bushes.
2 weeks. During the review hearing, I can't believe, I don't know what it is about me. I mean, I really don't. I really should have been fed up a long time ago. I mean, he made me send him to jail. How many times you go to jail on this? Once or twice?
Twice.
For how many days?
5 apiece.
Heather, give me a date in 2 weeks, please, or whenever, 3 weeks before I go anywhere and and it's not on Judge Heston's docket. What are we gonna do? July the 1st?
So that, not on her docket.
I want it
will
on my
be-
docket. This should be
your
on my
docket will be
docket
July 1st for Brownstown.
at 8:30. Okay?
Can I just make a note about what needs to be done?
Yes.
Just so that he knows that.
Yes, absolutely.
So looking at the sentence, going by line, first, the 2 vehicles that are parked on the grass, they need to be on impervious,
I want you to listen very carefully to him.
must be located on concrete or asphalt driveway surface. They also must be roadworthy, so the flat tires on the RV and cars, those are not roadworthy, so they need to be made roadworthy. The garage was taken down, the permit was pulled, however, there's still no inspection, so it's not completed, so we need to contact the township, have them get out there and make sure it's safe.
Do you understand that?
Yeah, I thought he was the guy I had to have come out and look.
Well, you can set it up with him right now.
So
I'm not the.
Yeah, I know, but can't you help expedite it by?
Absolutely, I mean, and also the cement's still there for the garage, the cement has to be removed. So that to get the permit to be passed,
Right,
the cement has to be, so I'm not a building inspector.
right, I know.
But when I spoke with him yesterday, he said he would not pass it because the cement is still there, the broken cement.
I want to keep the cement there to park the stuff on.
The cement is broken, raised.
It's a cement floor from the garage.
I made the orders initially. You need to follow them and go back to the probation order where everything was attached. And then you prepared another order on this case, correct?
We did, Your Honor.
And it's attached to the probation order.
Then I also gave Mr. Boyd a copy the last time.
I know, see, you gotta follow that, you gotta read that, get your son to help you, get somebody to help you. But if they don't pass it, it's no go.
What's wrong with keeping the cement?
You talk to them about it. I ordered you what to do and I expect you to do it. 3 more weeks, that's it. I can't extend probation anymore under 771. You're coming to the end of the year.
Just to be clear, Your Honor, 2 motor vehicles off of the grass from concrete.
Correct.
Asphalt and roadworthy, and get the building passing grade from the building inspector.
Exactly.
The garage.
There's a whole order.
It's more that's coming.
There is, yeah, so there's still junk, trash, rubbish, garbage throughout the property.
That's pretty clear. You gotta get rid of all that
I am.
within 3 weeks. Go ahead.
There's no trailer storage, so there's multiple vehicles that are being used as outdoor storage. That can't happen in the township. As Mr. Harris stated, the cement needs to be removed from the garage demo because it's all busted up, so it can't be used as like a pad for parking. The grass and noxious weeds need to be taken care of. There's an ordinance where it's 6 inches.
It's 8 inches, but I mean, there's weeds there that are taller than me, especially at the side of the house.
You gotta get rid of them.
Sure.
That's about it.
Home's gone.
Get rid of it, please.
Fight over that cement. I have to have them to park the vehicles on. They order me to park the vehicles on cement. That cement is fine for parking the vehicles on.
Well, you haven't, he's not the building official.
I
You know what
know.
I mean? But he's gonna help you get in contact with the building official before you leave here. You
Yeah,
can explain that to him, and he's gonna come in here and talk to me in 3 weeks. If you don't resolve,
okay, we'll see what you do.
let's get it done. Can't believe I'm not sending you to jail, Mr. Boyd.
Thank you, Your Honor.
Your Honor, I appreciate your benevolence.
Good luck. Sean Thompson, Deshaun Davion Thompson, 2.
Well, friends, I'm kind of at a loss for words, just like you guys. Maybe for tomorrow's sidebar, we should discuss why McNally is so relatively easy on this guy compared to what we would expect. I don't know. Something we can talk about backstage. Anywho, I hope you all had fun today. I know I did. Thank you for joining me. We'll be back tomorrow, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour early for channel members. I leave you with this wisdom for today. Let no evil talk come out of your mouth, but only such as is good for edifying, as it fits the occasion, that it may impart grace to those who hear. That coming to us from Ephesians today. By the way, I had somebody ask me if the daily wisdom will always be from the Bible. The answer to that is no. We'll draw from other places as well. I have a list, so we will share. Thank you all so much for joining me. Look forward to seeing you all tomorrow. In the meantime, go have yourselves a great day. Take care. God bless.